For reasons mentioned in the order, this interlocutory application for suspension of sentence of the applicant is hereby dismissed. However, considering the grounds taken by the applicant in the connected appeal, the applicant shall be at liberty to make a separate prayer for out-of-turn listing and expeditious hearing of the connected appeal. Yes.
May please the lordship. My lord, we have filed a bail petition, anticipatory bail application before vacation. Matter is not coming in the list, my lord. May I pay
Matter
for,
relates to
mails to my lord, anticipatory bail, my lord.
offense punishable less than 7 years.
My lord, the allegation has made that he has grabbed the land of the
What is the
informant.
punishment?
My lord, it will
You-
be
You verify and then mention.
my lord.
May please lordship for listing for IA lordship, third time left over, honorable this court lordship, for bail on Monday. lordship.
Okay.
Diploma.
May I appeal, Lordship? I beg to mention regarding item number 22 of today's list, Lordship. This matter came up before your Lordship before vacation, and your Lordship has fixed this matter today. Probably it will reach before 2. If it does not reach, the Lordship may take it up at 2, Lordship.
We'll take it up serially. It will reach today.
Your Lordship has on earlier occasion, your Lordship said that if the matter is listed, you make a mention, then we will take
No,
up.
today it will reach.
Lordship. Oh, Lordship.
Regarding item 26 as well, your lordship, you may fix a time at your convenience, at the court's convenience.
We'll try to take it up today.
Applies.
May I please, your lordship? Lordship, I beg to mention item number 25, lordship. On behalf of Mr. A.M. Bora, we need some instruction, lordship. Kindly adjournment for the day. I pray for.
Which one?
Item
Mr.
25.
V.A.
Yeah, better get it.
V.A. Chaudhary, learned counsel for the petitioner who seeks an adjournment on the ground that he has to take some instructions from the petitioner. You have it. Who is for the other side?
The state, lordship.
State, okay. Considering the grounds mentioned by the petitioner, the prayer is allowed. Let this matter be listed after a week.
After. Highly obliged.
May I please, your lordship? Lordship, I beg to mention item number 3, lordship.
Item number?
3.
Yes.
Lordship, I would like to withdraw the case as per the instruction of my client.
Heard Miss M. Das, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal revision petition. Considering the submissions made by learned counsel, the prayer is allowed. This case is dismissed on withdrawal.
May I please, your lordship? Lordship, with regard to item number 6, my lord, I pray for taking up this matter in the next week, my lord. Any date, my lord. Today we have some difficulty.
Heard Miss
B. Bora.
B. Bora, learned counsel for the petitioner. Why you are praying for adjournment?
Today we have some difficulty, my lord. Next week, any day.
Who makes a prayer for adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed after a week.
Lordship, may I,
No fixed
pray
date.
for,
After a week.
any date, my lord?
No, let the registry fix the date.
My lord, motion matter, that is why praying for a date. my lord.
Okay. 26th
Sure.
April.
Give your blessing.
May I please, lordship? Sure, beg to mention item number 16, lordship.
16. Yes.
Conducting counsel is out of station for medical purpose.
Heard Mr. What is your name?
NZ Chaudhary.
N.J. Chaudhary, learned counsel for the petitioner, who prays for an adjournment on the ground that conducting counsel for the petitioner is out of station for medical purpose. Considering the submissions made by the petitioner, the prayer is allowed. Let this matter be listed after a week. You are on interim.
Yes, lordship, kindly.
The interim order shall continue.
Here updated diary is required, my lord. So fixed date may be given.
Okay, the interim order may continue. Learned additional public prosecutor submits that the case diary which has been received is not up to date and therefore prays for calling for an updated case diary. Prayer is allowed. Let this case be listed on
30th, yes.
30th April for updated case diary.
May please your lordships. One order matter, my lord, and criminal petition, my lord, for listing, my lord, on my lord, on 23rd, if possible, my lord. On 23rd of
Okay.
Obliged.
May I please, your lordship, I beg to mention item number 21, lordship, matter pertains to anticipatory bail application, lordship. The engaged counsel is out of station, lordship.
Heard, Mr. What is your name?
R Islam on behalf of
R.
ML.
Islam, learned counsel for the petitioner who prays for an adjournment on the ground that the conducting counsel is out of station. Considering the ground, the prayer is allowed. Let this case be listed after a week.
There
You
are
are-
interim,
The interim order shall continue till.
CD is issued.
The case diary shall be retained till next day.
obliged.
May it please your lordship. I am praying for listing of an anticipatory bail application tomorrow for withdrawal, lordship.
For withdrawal?
Yes, lordship.
Okay.
Deeply obliged.
May I please, your lordship, call for the case diary, lordships.
Heard, Mr. A. N. Ahmed, learned counsel for the petitioner, also heard Ms. B. Mia, learned additional public prosecutor. Perusal of the case diary will be necessary, hence call for the case diary. Fixing-
Hattigaon, next week,
fixing-
Lordship, and the
fixed date be given,
informant,
26?
is the party, lordship, the POCSO case,
or POXO matter, then notice should go. my-
through the OC, lordship.
Just
Mm.
call for the case diary. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice to respondent number 2 as per the mode prescribed by a division bench of this court in the case of Deepak Naik versus State of Assam.
Scan
The
copy
pet-
দিব, huh?
The petitioner shall take steps
Scan copy
within
দিব।
2 days from the date of this order. Let this case be listed again on
Lordship, then if the notice goes, yes.
3rd of May.
Lordship, they'll serve a scan copy of the
Yes, as
petition.
per the.
জায়গা হয়ে গেছে, জায়গা হয়ে গেছে। এখানে আমি সব করি।
The petitioner is a resident of Bongaigaon, your lordship. He has was implicated one case, your lordship. And he has filed this petition for transfer the
Now, what is the
Yes,
ground?
from Hamden to
What is the ground?
ground ahead history paragraph 6 and 7, your lordship. It is not the your lordship.
Have you
FN
filed any FIR? You have been threatened by the co-accused.
Lordship. Now, co-accused said that informant that had threatened that if he appears, then he'll face their consequence, but he is not aware about that case and he is not never visited that place. Your
No,
lordship.
why are you praying for transfer? What,
It's for fair trial, if he is taking his right of any consequence. Because they are
no, you
also
have not yet stated the ground.
No, your lordship, I have stated yours.
No, that I am putting a query.
The paragraph 6 and 7, your lordship.
What you have stated.
Stated that your lordship is falsely implicated in this case. The affair name is not, he is not able to.
That
track.
cannot be a ground
No,
for
that
transfer.
another fact is that one co-accused is APR, he falsely implicated the petitioner. That petitioner has said that he transferred to the account of 15,000. And informed from him in the co-accused, the informant said that if he appeared, he will face their consequence. Certain time.
So co-accused has threatened you. Threatened you. If you appear,
No, not co-accused. Co-accused said the informant side has threatened.
informant has threatened.
Threatened stated inform of co-accused and co-accused intimated us because he is not aware about that place. He's from Bongaigaon, your lordship, and case is at Hamden.
That place is within Assam. Yes, Ms. Mia, what is
Yes.
it?
Lordship, the ground here stated at para 7,
that he never visited West Karbi Anglong district and he has come to know from reliable sources that Hamren is a remote area and the informant is a man of danger in nature. And he stated before Said Noor Islam SK that the petitioner has to face dire consequences on his appearance before learned trial court and Hamren. That
That cannot be a
ground
ground.
cannot be substantiated.
Because he never made that informant site also, never.
What
At
is-
bail, your lordship may issue notice that
Because I am transferring from that place to only Hosai also.
No,
Yeah.
you don't have a ground, valid ground.
The other ground is not
How-
there because he's never visited that place, never made the informant.
That cannot be a ground for transfer, that you never visited a place.
No, yes. Because the court.
Heard
was already-
Mr. S. Islam, learned counsel for the petitioner. Also heard Ms. B. Bhuyan, learned additional public prosecutor. This application under section 407 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shahidur Ali under, no, 407. Shahidur Ali praying for transfer of PRC case number 22/21 from the Court of Learned Chief Judicial Magistrate Karbi Anglong Hamren to the Court of Learned Judicial Magistrate Hojai Shankar Devnagar. Okay. Issue notice to the respondents since learned additional public prosecutor appears for respondent number 1. No formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with ID within 3 days from the date of this order, returnable after 4 weeks.
Well, this is a revision application, man. There's the judgment passed by the Learned Court of Sessions at my Kamrup Mexico, my lord. This is an act proceeding, my lord. Now, the Learned Appellate Court has confirmed the judgment passed by the my lord Learned Trial Court, my lord. And the grounds I have stated in my petition, my
The respondent is appearing.
Yes,
please.
Okay, what you have to say?
Lordship, there are no grounds for this revision, Your Lordship, because when out of every ground, they have admitted the check, they admitted the signature, admitted the transaction.
Yes.
My lord, kindly see, my lord.
Only point now they
There
are
are
coming.
there are page number with all respect, my lord. Page 37, man. Page 37, my lord. The account became NPA, my lord.
Page 37, yes.
Page 37, my lord. Lordship, first paragraph, however, Lordship is found it, my lord. First line
Page
of,
37 is the impugned judgment.
my lord.
Which para you are reading?
First paragraph, my lord,
Okay.
first line of the
Yes.
stanza. However, he replied to the learned court that the loan account was NPA. PW1 further admitted that on 6/12/17, he was not working at the GS Road branch of Complainant Bank and he did not personally know signature of the appellant since he did not put his signature on the check in front of him. Now, Lordship, this person PW1 happens to be a person from the bank with an authority letter, my lord. In case of AC Narayanan, my lord, if a power of attorney holder or a authorized person, my lord, deposits as a PW, my lord, he is to be conversant with the transaction and he should witness that transaction. So apparently, my lord, possibly this point was taken in the trial court as well as the appellate court, but this point was not addressed by the learned trial court as well as the appellate court. So, my lord, possibly this.
No, whether the trial court relied upon PW1.
Yes,
Or-
in that
He was
case,
the
I
only
will bring your
witness examined, my lord.
Lordship's attention to page number 20 here. Lordship,
He was the only witness examined, my lord.
page number 20, Lordship, the trial court
Yes,
order.
sir.
May I read, Lordship? Second line, but in an instant case, it appears that the accused has failed to discharge the initial burden by adducing evidence, and the said impugned check was not issued by him to the complainant in discharge of his legally enforced liability. The complainant, by producing the loan agreement by Exhibit 2, validly portrays the legally enforceable debt on the part of the accused. Now, this is
No,
a
no, Mr. What is your plea?
I place this fellow's PW1, the sole witness, my lord, as examined by in the trial court. He cannot be a witness for the prosecution, my. That is my point, my.
Why?
Because he did not witness the transaction, my lord, because at that relevant point of time, when the loan was sanctioned, he was not present at that
But
relevant time.
have you denied that you have not issued the check?
My lord,
may I further read in that line, your
Just a minute, let him complete.
my
because it is already.
I'll come.
My lord, first of all, my lord, in a proceeding under an act also, my lord, initial burden rests upon prosecution, my lord. If lordship goes through the judgment of A.C. Narayanan, he is debarred to the person whosoever is not witnessed, has not witnessed the transaction, my lord.
If he himself has not witnessed the transaction,
My lord,
he cannot be a
witness, my lord.
witness to that.
Yes,
Yeah.
that
Fact.
transaction, my lord. So on that count also, let it be, my lord, heard, my lord, and decided, my lord. Initial burden
No,
always.
but this case is based on oral testimony or the
PW1.
documentary evidence.
Document.
Oral testimony is to be there, my lord. Because the.
You
check-
have not, have you denied that you have no this
my lord.
legally
Lordship will kindly see,
enforceable debt against
No, my
the,
Lordship will kindly see, my lord, house loan was taken. And against that 35 lakhs was sanctioned by the bank. But they have issued 30 lakhs, to which I have issued 29 lakhs something to them, check,
by check.
as a security.
That check was,
That check got bounced, my lord. But in between, my lord, I have also paid an amount of rupees 14 lakhs. That plea was taken in before the learned appellate court, my lord. Lordship will kindly see. So it is a matter to be examined by your lordships, my lord. Lordship, paragraph 34, paragraph 5.
no, where first appellate court heard? Because this is a revision against the
My lord, my lord,
order of an
Appellate court.
appellate court.
my lord.
So the scope is very, very limited.
I know, my lord, I know,
Where it has heard,
my lord.
where the appellate court went wrong,
My lord,
what wrong has that
this matter was never discussed regarding
it relied on
PW1 being
PW1.
capable of being a witness in this proceeding. This plea was specifically taken, my lord. So let it be decided before this honorable court, my lord. This is a serious matter, my lord. If PW1 evidence goes, my lord, the case will crumble now.
Yes.
Lordship, first I'll take your lordship to page 20. The second part I was reading.
Yes,
Lordship, the trial court's order. In the cross-examination of PW1, Lordship got it.
Page number 20.
20. Lordship, that's the trial court's order.
Yes.
Lordship, in the cross-examination of PW1. Sixth line.
Sixth
Lordship,
line.
what is-
17.
Yes.
In the cross-examination of PW1 cross-examination, it appears that the accused did not dispute the validity of Exhibit 2. However, raised the point of PW1 was not present at the time of sanctioning the loan. In other words, he indirectly admitted the execution of the loan agreement. Therefore, under such circumstances, I may presume that the accused incurred legally enforceable debt. Lordship,
No, that is his plea.
yes, Lordship, but he has admitted to the loan agreement. If he has admitted to the loan agreement, the PW1 has to sustain the evidence or the initial deposition, whatever has been given.
No, but
But
that
in
has
case-
to be examined.
That has-
But for admitting, you have to pay 20%.
20%.
my lord, so far as 148 is concerned, my lord, of enactment, possibly it is the appellate court who can, my lord, give such a direction. So as on today, my lord, he is now financial hardship he is facing. Well, 10% my lord, it can be considered. That
My lord, I
I
would say
can-
stick to 20%
well,
because it
10%
is
will
minimum
be
of
as of today,
20%.
because this point is a valid point, my lord. If PW1 can be a witness. That is the moot question, my
And
lord.
lordship, in AC Narayana, there are two parts. The first part is he has to knowledge about the transaction. Second part, he has to have the knowledge about the transaction. Now, in this case, the
No,
PW
that we will examine.
My lord, that
Well,
has to
that
be.
can has to be examined.
What 148 says,
That my lord, lordship will find. 140, power of appellate court to order payment pending appeal against conviction. I can.
no, but that power is with the revisional court also.
Yes, lordship. The power is.
That
with
is
the
why I'm
union
saying
court
that.
also.
That let it be 10% with half with folded hands.
does
my
that-
lord.
No, what the statute says.
No, that statute
Not
says
less than
20%.
20%, not less than 20%.
Not, then it has to be 20%. On that ground, I am,
Shall be minimum of 20% of the fine or
Considering
complaint.
the ground taken, my lord, with all respect, my lord, can it be, my lord, 10%, with all respect and full respect? Subject to, my lord, my admission by my brother, my.
you are conceding,
No. 20%,
Mr. A. This is item number,
Two, my lord.
heard Mr. N.J. Das,
Right.
learned counsel for the petitioner. Also heard Mr.
P. Sengupta. for
P.
the-
Sen Gupta, learned standing counsel, P. in Punjab National Bank. This application under section 3401/397 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Atik Ahmed, impugning the judgment and order dated 2/4/2024, passed by learned Sessions Judge Kamrup Metro in criminal appeal number 19/2023, whereby the judgment dated 22/3/2023, passed by learned Judicial Magistrate First Class Kamrup Metro in CR case number 1195/2018, has been upheld by the impugned judgment of the trial court. The petitioner was convicted under section 138 of the Negotiable Instrument Act and was sentenced to undergo imprisonment for 1 year and to pay a fine of rupees 35 lakhs by way of compensation. And in default of payment of fine, to undergo simple imprisonment for 3 months. The contentions raised by the petitioner in the instant revision petition needs to be examined. Hence, this revision petition is admitted. However, it is subject to payment of 20% of the fine amount imposed on the petitioner. When will you pay?
But it says. that
Where he
within
will pay?
60
Within
days.
60
my-
days.
Within 2 months
Right.
from the date of this order. Where will he pay? To
Regis-
the
To
registry,
the complainant
to the registry.
I pay him also.
with a draft or check.
Okay, to the, what 148 says?
148 says, my lord, I can pass. it.
No, you read out.
Not.
Where?
It doesn't say where, my lord.
Okay.
Uh,
To
It
the-
has to be with the complainant because the next part says the complainant
To
shall.
the complainant within 60 days from the date of
Right.
this order. No formal notice need to be issued to the respondent, as the counsel for respondent has already appeared. Please this call for the case record of CR case number 1195/2018 from the Court of London, GMFC, Kamrup Metro, as well as case record of criminal appeal number 19/2023 from the Court of London Session Judge Kamrup Metro, list this metro.
After 8 weeks,
After
8 weeks that.
After
he
eight-
wants to
after
promote
8
it.
weeks. One more, in view of the orders passed in the main criminal revision petition, this interlocutory application is disposed of. What was the prayer in the?
For allowing him to go on bail, man,
Okay,
because there is direction to surrender, man, by the appellate court, man.
that is,
That will be considered after the payment.
Well, in the meantime, warrant will be issued.
No, I will not take steps on the warrant that I.
Well,
That
let it
assured.
be considered till the next day. I may be allowed to go on bail, man. Till the next
Till the
day.
next date, he may be protected, but not fully. I may.
Or I will be allowed to remain at
I,
prison.
this interlocutory application has been filed for suspension of. Presently, you are on bail.
I am on bail, man. But the.
Suspension of sentence imposed on the applicant by the judgment which has been impugned in the criminal revision petition number 147/2024. Stop. This interlocutory application shall be considered on after receipt of the trial court record, which has already been called for in criminal revision petition number 147/2024. However, in the meanwhile, till the next date, in interim, the operation of impugned judgment shall be kept in under suspension, and the petitioner shall be allowed to remain on previous bail granted by the trial
Okay.
court.
Published.
List along with the criminal revision petition number 147/2024 after four.
I'm obliged.
The matter pertains to Jima of a vehicle, my lord. The petitioner approached the trial court, my lord, but that was rejected, my lord. And
Where is the why it was rejected?
it was rejected, my lord, on the basis of the police report.
What was the report?
Well, it stated that the car was sold to someone else in the year 2019. But the car is vehicle, my lord. The vehicle is financed by a financier, my lord. So the vehicle is under hypothecation. As the vehicle is under hypothecation, my lord, that cannot be sold to someone else. We have annexed the RC also, my lord. RC, my lord, will find it page
No,
20.
on what ground it was rejected?
That is the ground, my lord, on the basis of the police.
You are not the owner.
Not
That-
the owner.
That was the ground.
That was the owner,
How will we find out?
my lord.
How will we find out who is the owner?
Exactly, my lord. Who is the owner, lord, in the court, or that cannot be found out, my lord. But the RC is there. And the ground of rejection was that the vehicle was sold to someone else. But as the vehicle itself was under hypothecation, my lord, that cannot be sold.
Where
Page
is,
29 is the registration certificate,
where is the impugn order?
my lord, at page 30 onwards.
What is your name? Badrul.
Badrul. He is the registered owner of the vehicle, man. Artiga vehicle, man.
Charge sheet has also been submitted in the case.
Okay, only because of the fact. Now, what is your submission?
No, well, the vehicle was, an agreement was made, my lord, that we have stated, agreement was made, but that could not be given effective as because the vehicle was under hypothecation. It cannot be transferred to someone else, my lord. So that the agreement was not executed. The possession of the vehicle was not handed over to someone else. The ownership, as the vehicle is under hypothecation. And the petitioner, he deals in rented vehicles, my lord. The vehicle was given on rent to someone else. That we have stated in our petition, my lord, and the vehicle was recovered from the house of the accused in this police case under NDPS Act. NDPS is registered under 21B.
Yes, Mr.
Your Lordship, the NDPS matter, my lord, not any other, that simple matter. And showing that agreement has done, that means he has taken some money, my lord. Agreement, you have not annexed, no? Agreement?
Agreement is with police, my lord.
Let a fresh report maybe call for, my lord, from the IO. What is the present status?
No, otherwise vehicle is not required for,
Vehicle is not, because search sheet has already been submitted, my lord. Search sheet has is.
I said submitted.
it was not given in,
Not give, Jimma was not,
whether Mr. This Samsuddin Laskar has claimed.
Yes.
he has not claimed till now. No
Heard-
one, no one apart from the petitioner have claimed the vehicle.
Heard Mr. P.K. Munir, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, read with Article 227 of the Constitution of India, has been filed by the petitioner Badrul Islam, impugning the order dated 21/9/2022, passed by learned Special Judge Karbi Anglong Difu in Jimma petition number 2328/2022. No, not in, against Jimma petition number 2328/2022, filed in NDPS case number 87/2022, whereby the prayer for Jimma of the Artiga vehicle bearing registration number AS02Z9532 was made by the present petitioner was rejected by the learned special judge in the learned counsel for the petitioner has submitted that the petitioner is the registered owner of the seized vehicle, and to substantiate his submission, he has furnished the photocopy of the certificate of registration of the seized vehicle. It is also submitted by learned counsel for the petitioner that the learned special judge Karbi Anglong had rejected the prayer for Jimma of the present petitioner merely on the ground that the officer in charge of Khotkhoti police station had submitted a report wherein it has been mentioned that a deed of agreement was entered into by the present petitioner with one Samsuddin Laskar for sale of the seized vehicle, and the said agreement was uh, executed on 31st December 2019. Stop. Learned counsel for the petitioner has submitted that the seized vehicle has been purchased through bank finance, and it has been hypothecated to the financer Mahindra and Mahindra Finance. Finance company or what? Mahindra and Mahindra Finance.
Finance.
And the petitioner has not transferred the vehicle to the said Samsuddin Laskar, though a deed of agreement was executed between him and Samsuddin Laskar. Stop. I have also heard learned additional public prosecutor. For sake of convenience, the impugned order dated 21/9/2022 passed by learned special judge Karbi Anglong is quoted herein below. Stop. Quote koribo ইয়াৰ পৰা. From page number 30. Quoted herein below. Stop. Next slide. From mere perusal of the petitioner, perusal of the impugned order, it appears that the prayer for Jimma was rejected by the learned special judge Karbi Anglong only because the additional public prosecutor had tendered objection before the trial court as the owner of the seized vehicle could not be ascertained. However, from the materials from the documents annexed along with this criminal petition, more specifically the certificate of registration, it is apparent that the present petitioner is the owner of the seized vehicle and same is under hypothecation with Mahindra and Mahindra Finance Limited. Thus, apparently, it appears that the present petitioner is the owner of the seized vehicle. Since when seized vehicle is lying in the police station?
It was seized on my lord 28/1/2022.
22.
28/1/2022.
It is also submitted by learned counsel for the petitioner that the seized vehicle has been lying in the police station since 28/1/2022, and same is not required for either for the purpose of investigation or in the trial. Under aforesaid circumstances, no purpose would be served by retaining the seized vehicle under the open sky when prima facie it appears that the present petitioner is the registered owner of the seized vehicle. Hence, this criminal petition is hereby disposed of with a direction to with a direction to the learned whom
OC. Inve-
No, no.
Investigating officer of the yes, Kotkoti police station.
with a direction to the officer in charge of Kotkoti Police Station to give the zimma of the seized vehicle, that is Mahindra, that is Artiga Smart Hybrid within bracket white color bearing registration number AS 02Z 9532 to the petitioner on his furnishing a, what is the cost of Artiga?
Artiga vehicle.
15 lakhs
Around 15 lakhs.
with a, on furnishing a bond of rupees 15 lakhs for production of the said vehicle in connection with the NDPS case number 37/2022 as and when so required. Before handing over the said vehicle, the the officer in charge of
Kotkoti police.
Kotkoti Police Station shall also prepare an inventory and take photographs of the seized vehicle, giving detailed description of the seized vehicle. And thereafter, the bond along with the inventory and photographs shall be submitted to the learned sessions judge, learned special judge in Karbi Anglong for further reference in case in the NDPS case number 37/2022, which is pending before the said court. With above observation, this criminal petition is hereby disposed of.
And the bond will be indemnity bond.
Yes,
That may be clarified. Indemnity bond may be repeated.
bond or other indemnity bond.
Otherwise, they should be considered. I'm deeply obliged.
May I please your lordship? My lord, 482 application, my lords. My lord, the petitioner is owner of a private hospital with the name and style of Avanti Private Hospital, my lord. The informant on 23/2/2024 lodged an FIR before the North Lakipur Police Station, my lord. Wherein, my lord, section 376 was alleged against the petitioner, my lord. My lord, on the basis of the said FIR, petitioner was arrested and thereafter petitioner prepared an bail application before his honorable court, my lord.
What is the ground for quashing?
Yes, my lord, sir. My lord, on the said bail order dated 23/2/2024, my lord, which I have annexed. My lord, page number 23, my lord.
Yes,
Point number 5, my lord, there are additional PP, my lord, after going through the statement recorded under 164, made a statement that section 376, my lord, no ingredients of section 376 is made out from her statement, my lord. So, my lord, considering the same, my lord, no primary facie case is made against the petitioner. My lord,
no, the allegation is not of 376, it is of attempt to commit. So obviously there would be no ingredient of 376 because the allegation was only attempt and the victim ran away.
Lordship, may kindly see the forwarding report. Grounds of arrest, although he was released on bail subsequently, grounds has been
No,
cited.
bail is a different thing.
Lordship, but in the grounds of arrest, the certain points have been mentioned, my lord, on what
No,
one he was arrested.
on what ground you are seeking quashing? That there are no ingredients.
yes, my lord, that is one of the points. My lord. And as in that, I pray that, my lord, LCR may be called for and
No, unless you have grounds, your criminal petition may not be admitted. Because the allegation is itself of attempt to commit rape.
Lordship, so why I'm citing the
May I please, Your Lordship. Application number 482, my lord. My lord, what happened? My lord, by judgment and order dated 31/5/2017, my lord. The petitioner, he was convicted under section 138 of the NI Act. And he was the order to, my lord,
31?
31/5/2017.
Okay.
The operative portion of the this judgment, this order is at page 21. Page 21.
Yes.
Upon considering of all the aforesaid aspects of sentence, this court has imposed simple imprisonment of 3 months on the convict Rajendra Das for his offense under section 138 of the NI Act. A sentence of fine of rupees 6,50,000
Okay.
is also imposed on the said convict.
Okay, proceed. You were convicted.
I was convicted.
Thereafter, what happened?
Thereafter, my lord, I have undergone imprisonment for 4 months.
4 months.
4 months, 3 months, my lord, for a sentence and 1 for in default to make the payment. Well, this certificate is at page, my lord, given by the jail authority, is page 27.
Okay.
This is to certify a simple imprisonment conviction. SC 4396 Rajendra Das, son of so and so was convicted by learned additional chief judicial magistrate Borpeta, Assam on 29/23 and sentenced to undergo SI for 3 months and to pay fine of rupees so and so. In connection with an act, the accused has admitted in the jail on 29/2023 to serve his sentence, and he was released from this jail on 19/1/24. Thereafter, my lord, the complainant, he has moved an application, my lord, before the additional CJ, my lord, Borpeta again, that I have to undergo another 1 month for default in making the payment. And accordingly, my lord, pays, my lord, by the order dated, my lord, 21/4/24.
Page?
Page, my lord, 28.
Yes.
CR is put up today. By petition numbers are filed by complainant paying to issue non-bailable warrant against the convict for serving his attendance to serve the default sentence of 1 month. Hard and furious this year, however, before issuing warrant of arrest, I deem it fit to issue notice to convict for his appearance. Issue notice accordingly, complainant is to pass steps. Then, my lord, notice was
You have served out default sentence also
Lordship. Lordship.
on 9, 10, 11, 12. Okay.
I have undergone 4. My lord, thereafter, my lord, on the next occasion, my lord, 18/3, my lord, as I was remain absent and an advocate appeared before the court below, my lord, and to file an application, and on that application has been rejected and non-bailable warrant of arrest has been issued against me, my lord.
Okay, we are issuing notice.
Lordship, at the face of it, while certifying his the period of sentence, Annexure 3, page 27. The jail authorities has written, the accused was admitted in the jail on 29/2023 to serve his sentence, and he was released from his jail on 19/1 after serving his sentence. Only 3 months time.
No, 3, this calculate it,
20.
it is 4 months.
4 months, it is 4 months.
29,
4 months.
maybe I'm
Four-
the mistake. in
Third,
calculation.
Mr. U. J. Soikia, learned counsel for the petitioner. Also heard Ms. B. Punya, learned additional public prosecutor. This application under section 397 read with section 482 of the Code of Criminal Procedure has been filed by the petitioner Uday, petitioner Rabindra Das, impugning the order dated 24/1/2024 passed by learned Additional Chief Judicial Magistrate Borpeta in NI case number 47/2016 and thereafter and also order dated 9/2/2024 whereby the non-bailable warrant of arrest has been issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner had faced a trial in NI case number 47/16 under section 138 of NI Act before the Court of Learned Additional Chief Judicial Magistrate Borpeta, and by judgment dated 31/5/2017, the petitioner was convicted under section 138 of the NI Act, 1881, and was sentenced to undergo simple imprisonment for 3 months and also to pay a fine of rupees 6,50,000, and in default of payment of fine to undergo further simple imprisonment for 1 month. Learned counsel for the petitioner has submitted that the petitioner had already served out his sentence of imprisonment as well as sentence for default to pay the fine amount. He has learned counsel for the petitioner has submitted that the petitioner was detained in the district jail Borpeta on 29/2023, and after serving out the sentence for 4 months, which includes the default sentence also, he came out of jail on 19/1/2024.
Lordship, I'm sorry to interfere. He may appear before the Lordship. Today was the date fixed for appearance and NBWA was issued. What he can do, Your Lordship, on the next date fixed, when he can appear and inform the court, see, I have served the sentence.
We are staying it. We are staying the NBWA.
NBWA be recalled till he appears, my lord.
Be stayed, my lord.
Lordship, then
No, that we will do.
Lordship.
What was the line? Serving out the total sentence of 4 months. However, the complainant filed a petition before learned Additional Chief Judicial Magistrate, stating therein that the petitioner has not served out this default sentence of 1 month, and on the said petition by learned Additional Chief Judicial Magistrate, by the impugn order, issued the non-bailable warrant of arrest against the present petitioner. Stop. It appears we will dispose it off.
Yes, my lord. He'll appear before the learned court below,
Disposing it off. No, we will issue notice,
my lord.
stay the operation of NBWA. He will appear, but let the complainant come and satisfy this court why he has not.
Lordship, that will.
So far, my lord, recovery of the fine, my lord, that, as per the sentence, my lord, it is 357, my lord, the 1A, 1B. Therefore, that he has to go to the civil court.
Okay.
For that, he has to go, it is clear, my lord, in this B, my lord, in the payment of any person's compensation for any loss or injury caused by the offense, when compensation is in the opinion
No,
of the
no.
court,
Yes,
recovered
yes.
by such.
We are not.
Lordship may steady proceeding at this stage, my lord.
What was the last line? Stop. Issue notice to the respondents since the learned additional public prosecutor has appeared for respondent number 2, no formal notice need to be issued to respondent number 2. However, as regards respondent number 1 is concerned, the petitioner shall take steps for issuance of notice on respondent number 1 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Also call for the scanned copy of the case record of NI case number 47/2016. However, in the meanwhile, as prima facie, it appears that the petitioner has already served of the sentence imposed on him by the Court of Learned Additional Chief Judicial Magistrate Borpeta. The operation of impugned orders are kept in abeyance till the returnable date. The warrant of arrest, the non-bailable warrant of arrest issued against the present petitioner by the Court of Learned Additional Chief Judicial Magistrate Borpeta shall not be executed till the next date.
Much.
Lordship, may I pray
Eh.
for a date?
After 4 weeks, give a date. 8th May. Let this matter be listed again on 8th of May.
8th of May, lordship, little bit later, only for 12th of May.
12th of May. Okay, 12th of May.
The
Fair
13th,
13th May.
13th of.
May I please, your lordship? Malad, 438 bail application, malad. Petitioner before your lordship is a malad, practicing advocate, malad. Malad, FIR is at page number 15, malad. What is happened, malad, in the month of February 2022, malad, I purchased a plot of land, malad, measuring 1 bigha at Amseng Zorabat area, malad, which is a malad Tozi land, malad, one kind of government land, malad. And out of that 1 bigha land, malad, I sold 3 katas of land, malad, to these 3 informants, malad, 1 kata each, malad, for a consideration of rupees 5 lakh from each of the informant, malad. That is, malad, in the year of 2022, month was, malad, March, malad. After selling the land, malad, 1 kata, malad, on 1 kata of land, malad, I am residing there by constructing my house, malad, and I delivered the possession, malad, of that 3 katas of land to these 3 informants, malad. Thereafter, they, after constructing, malad, house over it, malad, they are possessing, malad, since 2002, malad, 2022, malad. Now, malad, in the recently, malad, under the apprehension that, malad, the government might, malad, be evict, malad, them from this said land, malad, because it is not a partial land, malad. So, malad,
How you have sold a
malad,
land which is not.
I
partial land?
purchased that land, malad. I have annexed the agreement, malad.
No, you are a lawyer.
This
You
is-
know what can be sold or.
It is a possessory right, malad. I purchased that right, malad. Immediately, malad. I have annexed all this agreement, malad.
Now, what is the allegation against you?
The allegation is that, malad, they are saying that, malad, may I read the FIR, malad. The humble submission of the informant of this SR is that with their interest of
No,
progress,
don't read it. Just tell me what is the gist.
malad. Now they are saying that, malad, the land which I sold to them, it's, malad, some other person's land, malad.
And therefore you have
Therefore,
cheated them.
malad, they want the refund of money, malad. The last
part of the FIR is important, my lord. As we want refund of our amount, so the accused person has been concealing himself.
Yes, Ms. Goya.
Lordship, let the case diary.
My lord, yes, my lord, paragraph 12, my lord, I have stated, my lord, I have already refunded, my lord, 2 lakhs
Mr.
of rupees, my lord.
Nazrul Islam Khan, NI Khan, learned counsel for the
S. Rana,
petitioner.
my lord.
Heard Mr. S. Rana, learned counsel for the petitioner. Also heard Ms. B. Bhoya, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, Command 1973, has been filed by the petitioner Ansarul Haq alias Ansari, who is apprehending his arrest in connection with Satgaon PS case number 44/2024
Is it
under
proceedable?
section 120B/406/420 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 23/2024, the informants, namely Vishnu Prasad Kalita, Srimati Usha Devi, and Shri Dhubrajyoti Goswami, had lodged an FIR naming 8 numbers of accused persons, including the present petitioner, inter alia, alleging that the accused persons named in the FIR sold a plot of land covered by Dag number 200 of village Am Singh, Jorabad, to the first informant. First informant at a consideration amount of rupees 5 lakh each, 5 lakh from each of the informant. However, when the informant went to land record office, they came to know that the said land has been mutated in the name of some other persons, and therefore the petitioner, the informant, asks the accused persons named in the FIR to return back the money. However, the accused persons, including the present petitioner, have not made any refund to the,
Lordship, already I have made 2 lakhs of.
that is the allegation,
No, no, paragraph 12, my lord, I have,
Allegation of what happens?
sorry, my lord, sorry.
refunded any money to the informants. Stop. Learned counsel for the petitioner has submitted that the land in question is not a periodic patta land, and it is a Toji land, and only possessory rights were sold by the present petitioner to the informants. However, it is submitted by learned counsel for the petitioner that the petitioner has returned back to whom?
My lord, paragraph 12, my lord, rupees 70 lakhs to informant number 1, 70,000 to informant number 1, and 1,30,000 to the informant number 3. The other amount, my lord, rest amount, my lord, I will refund, my lord. I have stated, my lord, paragraph 12, my lord.
Have already returned back rupees 70,000 to informant number 1 and rupees 1,30,000 to informant number 3. And it is also submitted that the remaining amount would be refunded back to the informants. Learned counsel for the petitioner has also submitted that the dispute between the informant and the present petitioner is civil in nature. Stop. On the other hand, learned additional public prosecutor submitted that the perusal of case diary would be necessary, hence call for the case diary. Fixing
It's in 10-5.
10/5 for case diary. In the meanwhile, considering the nature of allegations leveled in the FIR and the fact and the submissions made by learned counsel for the petitioner, namely Ansarul Haq, Ilyas Ansari, is hereby directed to appear before the investigating officer of Sadgaon PS case number 44/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Sadgaon PS case number 44/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 10th of May.
Right, ma'am. Item
Nine to again,
number 10 is same, my lord.
10. No, Pusa is up.
And be called.
Oh.
Please, Your Lordship. There is a 430 application, Lordship. Lordship will find the FIR on case.
No, just a minute, Rima.
10.
Item number 10.
10.
Same.
Same FIR, my lord. Accused number 6 and 7 are there.
Lordship, regarding the payment of money,
But they are not involved, my lord. Allegation is against accused number 1, my lord. That item number 8, my lord.
In this case, same order, some changes will be made. I will make those changes. Item number 10 and item number 8, same order, name of the petitioners will be different. And I will make changes.
Full length.
Lordship, page 10 is the FIR, Lordship, the 430 application, Lordship, page 10.
Yes. What is the allegation?
Lordship.
What is the allegation?
Allegation, Lordship, some machineries were taken from a complex, Lordship, from a construction site, and thereafter, Lordship, some person was caught in CCTV, Lordship. That is the thing, and 2 persons were arrested, Lordship, and entire thing has been recovered, Lordship. And this present petition was suspected to be one of the member, Lordship, of that group, Lordship. And the thing is that, Lordship, I am a government servant, Lordship. Let me appear and let them resemble with the photographs from the CC camera, Lordship. If I am involved, Lordship, then the opportunity to appear.
What do you do?
Lordship, I am a government employee, Lordship, that I have given that page 24, Lordship, is my identity, photo identity. Lordship. There is no chance of absconding, Lordship. I will appear, Lordship, and if something comes out, Lordship, then definitely my bail petition will be rejected. Page 24, Lordship, annexed.
What is your designation?
Designation, Lordship, PRO, Lordship, provision that they are categorically stated in the paragraph, Lordship, that Lordship. That on page
Yes.
5, Lordship, pump, power pump.
let the
operator.
city come, my
CD
lord.
has to come.
Yes.
Till then, Lordship, let me appear, government employee, no chance of absconding.
Government employee, his name appears in the
No, no,
FIR.
no.
Lordship,
Whatever
allegation is there against him, my
Whatever
lord.
it may be, Lordship, that
You are named accused.
No, not naming.
Not named.
No, not naming. Only the apprehension that, Lordship, that CC footage is there, Lordship. Let me appear and resemble it, Lordship, whether I am there or not, Lordship. That is the case, Lord. If I am there, definitely bail will be rejected, Lordship, if CD comes, Lordship. Only opportunity is because I am not going to abscond, Lordship, because I am a permanent resident and moreover, Lordship, a government servant, Lordship.
You are what? Former?
Lordship.
The permanent resident is there.
Permanent resident of that
He come for
locality. It is called a power pump operator in irrigation department. So the identical district official.
Suri comes.
Only
Then
till the CD comes, Lordship.
Theft, my lord. Allegation is there of theft.
Maybe
Being a
they are
government
lordship. I'm not
employee,
denying
my
the
lord.
that lordship. Maybe they are lordship. Let me appear one lordship because there is no chance of my absconding. If intimation is granted, I will not abscond lordship. I'll have to.
No, why are you apprehending if your name is not there in the FIR?
The police are looking for me lordship. Maybe lordship, the lordship that the co-accused have stated something lordship. Maybe they are lordship. Let me clarify lordship. Let me appear before the
No, then we'll fix short date.
Short date. Tihu.
I'll appear lordship only till the lordship CD comes lordship.
No, if you are saying that co-accused have named you and you might have appeared in the CCTV.
But that part only to be clarified, lordship, that I will be present there before I will lordship, footage will be there, lordship. I am there, definitely it will come in case diary, lordship, that it is the person has been captured in CC footage, lordship.
Let the CD come, my lord. Short date be given
When can you produce?
from Nalbari. In the coming week, my lord. On 26th.
26th. Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Ms. V. Mayal, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant anticipatory bail application, hence call for the case diary, fixing 26/4 for case diary.
Much obliged, your lordship, much obliged.
And then 29 of supplementary.
May I please, your lordship? This is an application for quashing of an impugn order, my lord, where I have been made an accused in this case, my lord. What happened, my lord? Lordship has probably remember this case. In this case, my lord, the 7 search sheet has been laid down before the special judge. In all the 7 search sheet, I have been made as an accused. My witness.
On last occasion, you prayed for some time.
Yes,
You are
lordship.
ready?
And then thereafter, 3 occasions, the matter came up.
Okay.
Adjournments have been taken. Lordship.
My only, before he,
Let him complete.
only argument here, my lord, I'm not on the factual merits of the case. I am only on the procedural lapses committed by the prosecution here. Only regarding the law point, my lord. Whether I can be an accused without an search sheet, my lord. That is my whole case, my lord. Lordship, before going into, I'm just like to show 2 provisions of the Act, my lord. The section 5 of the Prevention of Corruption Act, my lord. Lordship, kindly see the section 5, how the court can take cognizance, my lord.
Now you are behind the bars.
I am out of the bar.
You are on bail.
Yes, I am.
Okay.
But what happened, my lord, when I have filed the bail application, my lord, during that time, they have filed a petition to make me as an accused in this case. And accordingly, on the petition, 1-page petition, my lord, the court has made me an accused in that particular case on the basis of the prayer made by the prosecution. Now, section 5 of the Prevention of Corruption Act, my lord,
PCI. Yes.
now, my lordship, no, this is not a case of 319, my lord. So this is a prior to 319, my lord. Though the trial has started in the other case, my lord, the main case, where the 7 search sheet cognizance has been taken, thereon on the further investigation is going on. During further investigation, they have found some material. Under those material, basis of those material, they filed a simple 1-page petition before the trial court. And the basis of that petition, my status has been changed from witness to accused in this particular case, this is permissible or not, man. Now, the section 5 says the procedure and powers of
Now, this is the main question which is to be decided.
Yes, ma'am.
Whether a status of witness can be
Status
changed
of witness without a search sheet.
without a charge during
This-
investigation.
During investigation without a search sheet can be changed, my lord. By the court.
I am not by the police. I am on the court's order. We are agreed by the court order, my lord. My impugn order, we have.
No. Before going into this or deciding this question,
Yes.
whether materials would be required, case diary.
Lordship, I have
No, my
submitted a report
contention-
under what circumstances she was.
No, I'm not on
Permission
fact-
was,
Lordship,
even
that-
permission is not,
My,
is
I'm
required, your lordship.
absolutely not on factual metrics of this case, my lord. Absolutely no, my lord. Whatever the material they have collected during the further investigation, I have nothing to say. That's why I have said, whatever the material, but the whether without the search sheet, a person can be brought in as an accused and court can take cognizance of that offense without a search sheet.
Court has taken cognizance.
Yes, without a search sheet. That is my case, my lord. And made me an accused in this case without a search sheet. Now
And made you to face the trial.
yes, that is my case.
Okay.
So in that case, I have been without, this is not a stage of 319. In my case, there is no deposition and there are in the, all the search sheet, I have been a witness, admittedly. And the court has framed the charges against the other accused person before me. The trial has proceeded against the other accused person. Then, during the course of further investigation, they found some material. I'm not on that, whatever the material, maybe hundreds of material, thousands of material, I'm not concerned on.
No,
I am only.
one more query, one before you make your further argument. Can it be disposed of at this stage?
Yes, my lord.
Motion stage?
Yes,
You are convinced?
yes. Only
Can
point,
it be-
lordship,
Lordship
can
may kindly have a look at the report submit under what circumstances, what materials have
No,
been
no.
found against,
Without
lordship,
looking into it,
lordship.
can it be disposed of now?
I leave it to your lordship's
my
discretion,
But
contention-
material-
because in the meantime, developments have taken place in the instant matter,
No, you know his contention.
My lord.
He is on law point.
my lord. I think,
Let's-
lordship, my respectful submission is there is no infirmity, because when the material,
Okay, then let us,
later
Yes.
than lordship is disposing of, then the later CD come, my lord.
That is what I am
After
saying.
perusal of the
Why
CD.
this CD is necessary, I am not on the material, I am by again and again saying. Whatever the material in the CD, I am not concerned with that. But those material has to be placed under which as a report. Now this lordship kindly see the section 5. What are the requirement of the enactment, the statute? I am on that.
okay.
I am not on the hundreds of materials may be there in the CD.
Lordship, let the CD come and your lordship may dispose it of after good perusal of the CD. If there's error apparent on the face of the record, your lordship, because this, after further investigation has been made in pursuance of Honorable Division Bench's order to form an SIT. When the SIT was formed, your lordship, several matters have come up before the investigating authorities while they have undergone the further investigation, my lord. And your lordship kindly have a look at the materials which have been found against the instant
That is,
petitioner, my
that
lord.
is the my only point
Really,
is
your
that.
lordship, she'll be treated as a witness. Can it be so, my lord? When the materials have been found, she was arrested, subsequently she was released on bail, my lord. And
Yeah, my
I'm
lord.
told prosecution
No, no,
section has been
let me
obtained, my
complete
lord.
first, my lord, let me complete first.
No, I have put only one query to
My
both of you.
So kindly
Whe-
put the
whether-
query lordship to me,
Yes.
my lord.
Whether to both of you, whether if it is, it can be disposed of.
Yes,
by
my,
hearing both of you today, then I will hear it.
yes, my
If-
contention is that because I am not on material. My contention is not on material,
Only on law point.
only on law point, procedural law point, that too. I'm on procedure, I'm not on material, my lord. That has to be clear first. That's I'm repeating
Lordship,
again
then
and
for
again
that
and
also,
again.
for that
My-
reason also,
my-
your lordship may kindly go through the case diary once and your lordship may dispose of the entire matter on a hearing day. Today is the reopening day.
The
Let the
case
matter
diary
come
will not say the procedural part.
Because your
Yes.
lordship, even if your, when lordship takes a 482 application, your lordship goes through the case diary
It's
order.
not necessary. It's not binding
It's
on the
up to the
court.
court,
It is up to the court. Lordship has to see first my
Okay,
contention.
let me hear both of you.
Yes,
my lord.
If I feel that
Yes.
case diary would
Yes,
be
yes.
necessary, I will call.
yes.
Regarding the
Lordship,
law
not the-
point,
my-
your
my-
lordship,
Why? That's
Because
what
you
I-
have a small point.
Yes, very small point, my
How
lord.
much time will you take?
That I can't
Small
say, my
point.
small point, depending on the understanding of the both the sides, my lord.
No, I have to understand.
Even I
No,
have to
no, no, I have
understand.
to understand.
I am not as genius as my learned senior
No,
friend.
thank you. I took it as a
Stop.
compliment, though it is not a compliment, I know.
Start,
From
start.
the inner side, it's not a compliment, I know it very well, but I took it as a compliment,
Okay.
thank you. But anyway, my lord, Lordship kindly see section 5, my lord.
Yes.
Lordship, may I pray? Lordship, since the Lordship is disposing of, let the matter come up tomorrow. Tomorrow is Friday, Tuesday. Even if your Lordship is not calling for a case diary or the materials available in the learned court
The
period.
last time they have taken time, I have not objected.
I have not. Never
The
have
first
taken
time-
time.
First
First
day
time,
itself,
I have
the Lordship has.
3 occasions have gone by. They are taking time. One after your Lordship may kindly have a look at the order sheet.
Yes, I have to, because I was in the other court, not because of the other reason.
3 occasions. They have
Yeah, are you
seen they have
prepared on those
urgency.
occasions?
No.
Are you prepared on
Yes,
those
I
occasions?
was.
So you are, if you are prepared in on occasion,
Because
why you are taking time?
today Lordship's query is different. When a
No,
case
no, no.
I am praying for a
Absolutely
case
no.
diary.
That's the
Lordship.
first day itself. That is not the query. Why the case diary are necessary, Lordship will decide. First, Lordship kindly hear me on
Lordship,
the legal point.
since,
Why
Lordship,
if
on
she is all,
Tuesday,
she is
my lord,
prepared
or
for the case.
tomorrow, my lord, tomorrow.
Why tomorrow, my lord?
Tomorrow you can produce the case diary.
It
Well,
won't
first
be
thing,
difficult.
Lordship kindly decide whether the case diary is required or not.
No, if tomorrow it can be produced.
Case diary can be produced right now in the
Honorable
2 o'clock. This is
Saturday is a working day, it seems, my lord. Khula nahi hai.
my contention is whether Lordship kindly see at least one thing,
Okay, start.
see
Start.
whether case diary is
Let
necessary
me
or
hear-
not.
Let
Hello?
me, let
My
me hear,
contention, let it be clear
Yes.
first.
let me hear him.
My lord.
If then, my contention is Lordship kindly take the section 5 of the PCA.
Okay.
The special judge may take cognizance of the offence. Lordship kindly mark it. Cognizance of the offence.
You have annexed all the required documents.
Yes, yes. My contention is only that petition, by virtue of which I have been made an accused. Whether that petition can be treated as an charge sheet under 173(2)
Okay.
and made me an accused. This is the simple question, my lord. A special judge may take cognizance of offence without accused being committed to him. We are not on that. For trial. Now, the may take cognizance. The first of what? He can take cognizance. In trying the accused shall follow the procedure prescribed by the Code of Criminal Procedure 1973 for a trial of a warrant cases by a magistrate. So, while taking cognizance, he has to
CRPC.
follow
CRPC.
CRPC first of all, and the second, the warrant cases, which follows by the magistrate. Now see, what is the warrant cases? My lord, CRPC. Now, Lordship, can you see section 238?
Yes.
When in any warrant case instituted on a police report, first of all, police report. The accused is brought before the magistrate at the commencement of trial. Magistrate shall satisfy him and is complied with the provisions of the 207. Now, what is the first requirement is a police report.
Yes.
Now, what is police report, my lord? Now, Lordship will go back. Let us go back to section 2 R, my lord. Definition of the police report.
Yes. Yes.
2R1. A police report means a report forwarded by a police officer to the magistrate under section 2 of the section 173. That is police.
Okay.
So the magistrate or the special judge only can take cognizance of an offense on the basis of a police report under section 173. That's clear, my lord, as per the section 5 of the statute, my lord. There is no other way. Now, they are on the further investigation. So further investigation falls under section 173A. Let us see what is 173H says, my lord. Whether the 173 can bypass the police report now, or it has to again comply with 173 subsection 2 to subsection 5. All the materials. Now, what is the 173H says, my lord?
Yes.
Nothing in this section shall be deemed to preclude the further investigation in respect of a offence after a report under section 2 has been forwarded to the magistrate, and whereupon such investigation the officer in charge of the police station obtains further evidence, oral or documentary, he shall, now lordship kindly mark it, he shall forward to the magistrate a further report or reports regarding such evidence in the form. Which form, my lord? The form as prescribed under section 173(2).
Okay.
Form prescribed and the provisions of subsection 2 to 6 shall, now this is shall, this is mandatory, as far as may be, apply in relation to such report. That means as far as the first report, the final report under 173(2) has to comply it again in further investigation also. As may be applied in relation to a report forwarded and under subsection 2 from 2 to 6. So from 2 to 6, there are certain criteria. What are the has to be followed? And the lordship know that the famous judgment of the Ramaswamy, what is the final report says, what it contains, everything. So 2 to the so 2, what are the requirement of these two, my lord? It is a form, and the requirement 2 is very specific, 2 to 6, my lord. As soon as it is completed, the officer in charge of the police station shall forward the magistrate empowered to take cognizance of the offence on a police report, a report in a form prescribed by the state government. Now, this is very important, stating the names of the parties, the nature of the information, names of the person who appears
No,
be-
before you proceed, which is the impugn order? Impugn order?
Page 156, mine.
impugn order on the basis of a report, one application. Lordship first has to go on that application.
No, let us see the impugn order first.
The application is 151. This is not a report.
No, this is the application.
156, my lord.
No, the impugn order.
151 is the application and 156 is the impugn order, on the basis of which I have been made accused. First of all, my contention is that the application filed by them, whether it can be treated as an application under section 173(2), because that application, the requirement of the statute as far as the section 5 is concerned, the court can only take cognizance of an offence on the basis of a police report, not otherwise. And what is police report? That police report is under 173(2).
Now, where is that part of the impugn order where
Nothing, my lord.
where you have been made an.
Yes, yes.
Where the court has made an observation.
159, my lord. Last paragraph, 159. After considering the last paragraph I am reading, my
After
lord.
considering the
The
material.
materials collected by the IO, I am of the view that the interest of the proper effective investigation, change of the status of Sukanya Das from prosecution witness to an accused is necessary. Hence, the petition filed by the present IO petition. Lordship kindly mark it, it's a petition. Filed by the present IO is allowed and status of the Sukanya Das is changed to an accused from the prosecution witness. We are agreed by that, man. How the court, without having the search sheet, without a search sheet under section 173(2), which is the mandatory to take cognizance.
Okay, now proceed.
So that is my contention. Now the 173(2) Lordship 2 has seen the what are the requirement from 2 to 6. It all has to be followed under 173(2) as per the warrant case is concerned. The statute is very clear. It says 2 to 6. That has to be complied. Only then the court can take cognizance of an offense. Now here, and Lordship knows the cognizance is
2
taken
to
only.
6 2 to 6 is applicable
Yes,
only when the investigation is complete.
yes, in further investigation also.
After further investigation is complete,
Yes,
a further report has to be
Made it.
submitted
and or
complying with 2 to
Yes.
6.
then only my
No,
contention is
My
that,
query is, I have a query.
yes,
The
because
trial court in the impugned order has stated somewhere that for the sake of investigation, which implies, which I am
yes,
understanding in the way that investigation is not complete against Sukanya Das.
yes, not completed, but in between, can court take an accused, make me an accused without taking the cognizance? Because here there is no other provisions in between. Otherwise, what is the requirement of the 173(8) and further in report? For the purpose of taking cognizance, because he is taking cognizance of the offense every time.
No, but cognizance before filing of 173 also is there. After filing of 173,
No,
cognizance.
before 173 filing of, where is the provision of taking cognizance, my lord? Either it has to be under 193 in cases of a sessions court. Now, here, but in case of sessions court, he is a magistrate as well as sessions court. So, as far as the statute, there is no requirement of the committal. Otherwise, sessions case court needs a committal. Without committal, he can't take. But here is the only deviation is that the special court, without being committal, he has become the original jurisdiction. That was the section 5 says. But the section 5 also says that yes, without being committal, you can take the cognizance. But that cognizance has to be taken on the basis of a police report, not otherwise. Specific. Section 5 is very specific. Cognizance, you can take it. We are not on that. But basis of what, my lord? It has to be basis on a police report. And what is police report? It is defined under section 2R. The 2R says it is 173 subsection 2. And it has to be followed as a warrant cases by the magistrate in section 5. How the warrant cases proceed. And the warrant cases also says that the from section 2 to 6 of 173 has to be there. So that means when you will file a charge sheet, the final report, only then the court can take cognizance against me, not a merely petition filed by before a court, and court will change the status. Otherwise, what is the purpose of 319 then? Why the 319 have been enacted, my lord? During further investigation, everybody can be roped into when the trial has proceeded. Any person without the final report on a simple petition, tomorrow X, tomorrow Y, tomorrow Z, anybody can be taken. That's not the purpose. Because the purpose is that the court has to see what are the material on the basis of which a person can be again roped into in the trial. What are the material court will find? Court will has to see from 2 to 6. Then only the court can apply his mind. The material, the statement, everything. What are the 2 to 6 days, my lord? It's not an automatic, my lord, just a petition. They will find that we have found these material, so you make him act as an accused tomorrow. That is their case. They have filed simple one-page application before the trial court that we have found some materials against them. So you made him. So there is no scope for the court to apply his mind. Court is not a post office that this just the prosecution will give some material on one page that we have found so material, and court will accept on that and make a person an accused. So what are the requirement is that the requirement is 173(2). And the 173(2) says, what are the requirement, my lord? As soon as it's completed, it has to be under a form. First of all, the name of the parties, nature of the information, name of the person who appears to be acquainted with the circumstances of the case. D, whether any offense appears to have been committed, if so, by whom, specific, whether the accused has been arrested, specific, whether he has been released on bail, if so, whether he has been forwarded in custody. H, whether the report of medical examination that is that. Then 5, I'm not on 4 and 3 and 4. It's an only bond. The 5 is very important. Lordship now can see. When such report in respect of the case which section 170 applies, the police officer shall forward the magistrate along with the report all documents or relevant extract of thereof on which the prosecution proposes to rely other than those already sent to the magistrate during the investigation. Where is those, my lord? Now B, the statement recorded under section 161 of all the person whom the prosecution proposes to examine as a witness. Then 6. So, requirement of the CRPC 238. Section 5.
Yes.
Now, Lordship kindly see.
Yes.
The 173A is very specific in this regard. What are the requirements of a further report? The 173(8) says, he shall forward the magistrate a further report or reports of such evidences in form of a prescribed and the provisions of section 2 of 173 to 6 of from 2 to 6 shall, as far as may be, apply in relation. So he has to comply with from 2 to 6, all materials.
Okay.
So that it is not the, that's what is the requirement? So a judicial mind can be applied. Otherwise, what will happen, my lord? The prosecution will submit any report, any material on a 1 page or 2 page, whatever. But what are the requirements? So that the court can take the cognizance of the offense after applying the judicial mind on the basis of the material supplied under section 173 2 to 6. That is the mandate. Only then he can be termed as an accused, then only can cognizance can be taken. That is section 5. Now what they did here, the petition now, Lordship kindly see, page 151. One, this is a simple two-page petition, my lord. It is a prayer for permission to prosecute the witness, my lord. This is not a report under section 173(2)(8). There is no witnesses referred. So what are the requirements of this petition, whether this has been complied with, madam? How the court can take cognizance on the basis of a simple application, as they have said himself, that this is an application, this is not a report under section 173(2). Their own admission by the court, the report says this is a petition only for to take him, the petitioner, to make him as an accused in this case. The prayer also, the last paragraph, page 152. Hence, it is necessary to change the status of the Sukanya Das from witness to accused and to prosecute, and which has been allowed. Now, I have been allowed by the court to prosecute. I am on that. How the court can allow me to prosecute now? The prayer has been allowed without taking into cognizance of the offense under 173(8). Because that is the only provision by which a additional accused, maybe 1, 2, 3, 4, whatever may be the number, they can be brought into for the facing the trial. There is no bar at all. But not by way of this shortcut method, because these preclude from the court to take a decision, judicial mind, my lord. How the court will decide on this petition that this person is required without, that's why the cognizance of an offense is a very important aspect of a judicial process, my lord. A personal liberty can be curtailed by the 173(8) or 2. You are making somebody an accused. You are making somebody to face a trial. And facing a trial is not just a child play, my lord. So, a judicial mind needs to be applied before taking somebody, issuing process against somebody. So, how to apply this judicial mind? On the vacuum? Certainly not. That's why the statute says how to apply the judicial mind. For the application of the judicial mind, some material has to be placed before the court. And what are the material? From 2 to 6. This is very clear from the statute. That's why I'm saying I am simply on the legal issues. Whether these application can be treated as a report under section 173. If Lordship feels that yes, this is a report under 173(8), it mandates, it fulfills the all requirement of the section 2 to 6, then I have no case now. If Lordship holds it, that yes, this is a report under section 173(8) and it is fulfills all the criteria as stated from 2 to 6, which is the required.
No, whether trial court has treated it as.
No, nothing. Trial court has not stated. Simply on their petition, simply petition was allowed and means my status has been changed. I have been made an accused in that particular case.
But trial court has not directed you to face trial.
That's a different directed me. I have been made accused in the trial. What else is required? Whatever may be but my status has been the trial. One fact is constant, my lord. I have been taken cognizance.
On reading the impugn order.
I have he has taken cognizance of this report. He has allowed the prayer.
No, listen. On reading the impugn order, my
Yes.
understanding is that trial court has made you an accused only during the stage of further investigation.
No,
Trial court
face
has
the
done,
trial.
no,
No,
trial
no,
court has directed you to appear before the
no,
investigating
no,
officer,
whatever.
not before the court. You
No,
are
no,
not
that's a
appearing
different
before the
issue,
court.
madam. How can, what is the requirement of the then trial court to make an accuse me? What is the requirement, madam? Because if there's no requirement of the trial court to direct me to appear because I am already investigation is going on. What is the requirement of their petition filed before to make him as an accused?
That is my query. When once you are made a
Accused by
witness,
the investigating officer.
a witness in the
Yes,
charge sheet,
yes.
unless leave of the court is taken to treat as you as an accused, how investigating officer will arrest you without taking leave of the court?
No, there is no such provisions of
No
taking.
provision is there.
There is no such provisions in the CRPC to arrest a person.
One more query.
Yes, madam.
Your entire submission is directed towards the assumption that the petitioner is directed to face the trial without 173A.
Yes, yes, that is the reflected.
But my understanding is you are not directed to face the trial.
Yes, Your Lordship.
Still materials are,
Yes.
are in the stage of collection only.
Lordship kindly say,
Premature, my lord.
now 158, Lordship kindly see. The court has taken cognizance of the material against me. That means what?
150,
58 to face the trial.
where?
That is the 158, my lord, their finding of the court. Court has taken cognizance of the material, my lord. Why the cognizance of the material he has taken, my lord, then?
Where is?
It appears,
Yes.
paragraph 158, last paragraph. It appears that accused Sukanya Das was a candidate of the combined competitive exam in 2013 conducted by so-and-so, was selected at the post of Assam Civil Service Grade 1. During investigation, former IO recovered various answer script and the residence of the accused so-and-so, who was chairman so-and-so. The statement of the accused Sukanya Das was recorded by the former IO and she was shown as a witness in a supplementary CS number 1. During the course of the further investigation case under section 173(8), the present investigating officer is able to collect material against her. I have perused the material collected by the investigating officer against the accused Sukanya Das during the further investigation of this case. Which material, my lord? Also perused the statement of the recorded by further IO statement under 161 CRPC. In her statement 161, she has not disclosed anything material which helps the prosecution to establish the case against the accused person in the trial. It is difficult to understand as to why the name has not been cited as witness in supplementary citation number 1. However, during the further investigation, present IO is able to collect sufficient material against her. The criminal justice system seeks to maintain the order, protect the individual right, and to promote justice and by investigating and adjudicating terms in punishment order. There is no bar in law to change the status of the person from witness to accused. I am on absolutely no dispute on that. After considering the material collected by the present IO, this is very important, my lord. I am of the view that in the interest of the proper effective investigation, change of the status of Sukanya Das from the prosecution witness to an accused is necessary. Hence, the petition is filed by the IO is allowed and the status of the Sukanya Das is changed as an accused from the prosecution witness. So, I was made an accused in that particular case today, where the trial has already proceeded. Maybe further investigation is going on, that's a different issue. What are the requirements? Where from he has perused the material, he has taken the cognizance means what, my lord? Application of the judicial mind? And where from that application of judicial mind without a 173(8) proper report? And he has decided to change my status. Arrest is a different aspect, my lord. Changing the status is not necessary, my lord. For the arrest, they could have informed that we are going to arrest those. Even my humble submission is that a witness also can be arrested during the investigation if there is a prima facie material is found against him. There is no bar.
for the investigating authority. They can intimate. Definitely forwarding it report is the intimation. But in my case is that the taking cognizance by the court of the report of the petition filed by the prosecution on the basis of which my status has been changed in the trial. But in this case, trial is going on and simultaneously investigation is also going on. Both are going on. Let the investigation go now, we are not on there. But my contention is that the court has taken cognizance of that particular petition filed by the prosecution, gone through the material, applied it. That means what? He has taken the cognizance. Application of the judicial mind on the basis of what? The IO statement. But because the all cases, my lord, there's only two provision to status to change the status of a person. If he is not charge sheeted or not sent up for the trial, not named in the, even if there is some material in the charge sheet, previous charge sheet, if the court finds it, there are ample material against a person, though he is not charge sheeted, he can be taken as a accused under section the 319.
Okay, your main grievance is that you are made to face trial without 173A.
Yes,
That is
we have been made an accused because otherwise,
for facing trial.
yes, accused for facing trial, that is apparent. And even my status, changing my status by the investigating officer and changing my status by the accused, by the court is two different. Even 319, it is by the court. 173, it is by the court. When the process is issued in the same process of taking cognizance. In the process of taking cognizance, court first take the cognizance of the offense. Then he issued process to the person who seems to be involved in that particular offense. So cognizance is taken against a particular section offense. Cognizance is never taken against a person. It is a process. Then the process is issued. That's the law. Lordship knows it. Cognizance always is taken against the offense. Now here, he has taken the cognizance against me. That too, which offense I have committed in the trial. Under which provisions of law. Which section I have violated under the PC Act. There's nothing in the record. No, simply under their petition, my status has been over a night changed. We are on that. They can do it, but not, Lordship knows it. That's a very famous case, the Privy Council 1937. Nazir Ahmed case. The Nazir Ahmed case, which has been followed subsequently in all other cases, that when the statute says that something has to be done in a particular way, it has to be done in that particular way. There's no shortcut to that effect. Here is an absolute shortcut method they have applied for, which is not permissible. So my contention is this petition does not form a report. A report can be, this is not a report. The court could have said, they do whatever you like, but this is not the stage to, I am taking cognizance of the offense. He has taken the cognizance of the offense and made me an accused without a report. We are aggrieved by that. Because suppose tomorrow, what happens, Lordship, can you see a situation, madam? What is the dangerous situation because of this order? Suppose the further investigation is going on and they have found nothing tomorrow. Whatever material they have found tomorrow after the further, because it's continuation, and they have given a final report. But because of this order, there's a bar created because the court has made me an accused in this case. When court has made me an accused in this particular case, can the subsequent final report exonerating me can be accepted by the same court? Because same court already has made me an accused by virtue of this order. Can then court can review this order that now I cannot find, because you have already made me an accused in this case. On whatever the material. Suppose in the further investigation tomorrow, they found it that these materials are not sufficient to file a final report against me. Then what will they do? They will file a closure report against me. If they file a closure report, what will happen, my lord? By virtue of this order, I am already an accused. Then where shall I go? Which order has to be followed, man? That's the friction. That's why I'm saying that you have to wait for the final report against me, file a charge sheet in a proper form, let the judicial mind decide on the basis of the charge sheet as per the statute of section 5. Then you take the cognizance, not before that, because the investigation is going on. And before completion of the investigation, you have made me an accused in this case. Tomorrow there may be a situation where I may be exonerated in the further investigation. Then what will happen? Why you have made me an accused in the material, whatever the, what is the necessity of the final, waiting for the final report to come?
Okay.
So this petition rather is premature to make me an accused. That's why I'm saying that in this case, why the case diary is required? Only on the petition, that in this petition and this order, it says itself, it's absolute violation of the provisions of the CRPC and the provisions of the section 5 of the Prevention of Corruption Act and section 438, 238 of the CRPC. That's my humble submission, sir.
Yeah.
And our High Court also, our High Court judgment, Justice Rumi Fukar, that judgment is also goes in my favor, my lord. That judgment I have already, probably it is in the file. I can give another
Which-
copy, my lord.
Which judgment? Which judgment you are relying? Give a citation. Give this.
Shared Habibul. I'm giving another copy, my lord.
What it says?
That says that the only way is the 319, my lord.
Oh.
But I am not into that, my lord. Though it is in my favor, my lord, I am not on that, my lord.
Okay.
Because in that case also, it was a witness. Subsequently, court has so moto taken cognizance and may remain accused. Our High Court says this is not permissible.
This is in relation to 319. That
Then the court says only option is 319.
Okay.
Court says 319, but I am not in stating to that point, my lord.
No.
To be frankly speaking, my lord. My contention is before 319 also.
I have
there are-
understood your submission.
Yes, my. I'm not stating to that level, my lord. But my contention, even the 173 or 193, there has to be a charge sheet before the court. Only then the court can take cognizance of the offense and the offender subsequently. Not in a petition, and that petition also does not form a part, does not fulfill the requirement of the 173(2), which is otherwise mandatory as per section 173(8). The only from 2 to 6, it says 2 to 6 under 173(8) says all has to be there. And it is a word is shall. It's a mandatory. And there is a judgment also, full bench judgment of the Supreme Ramaswamy judgment. What is the 173(2) says, my lord. I can give that judgment also if required, my lord.
If you are relying on that, you may give.
Yes, sir. That's a one paragraph judgment. Only one paragraph is relevant. I'll give it citation also. The paragraph 73 says what is 173(2). It says 173(2) is what is the police report? Police report means from 1, 2 to 5, they have to comply with.
Yes, Miss Priya.
Lordship, Lordship, as I have submitted earlier, Your Lordship, the entire exercise has been carried out in terms of Honorable Division Bench's order, Your Lordship, to form an SIT. When the SIT was formed, the further investigation was done, and various materials, Your Lordship, have incriminating materials have been found against the instant petitioner. And as such, Your Lordship, the IO submitted a petition before the learned court below. And Honorable Court at page 159, Your Lordship, may kindly have a look, my lord. I have perused the materials. Lordship, may kindly have a look.
Yes.
I have perused the materials collected by the investigating officer against accused Sukanya Das during further investigation of the case, and also perused the statement of her recorded by the former IO under 161 CRPC. In a statement under 161 CRPC, she has not disclosed anything material which will help the prosecution to establish the case against the accused persons in trial. It is difficult to understand as to why her name has been cited as witness in the supplemented charge sheet number 1. However, during further investigation, the present IO is able to collect sufficient materials against her. The criminal justice system seeks to maintain order, protect individual rights, and promote justice by investigation and adjudicating crimes, punishing the offenders. There is no bar in law to change the status of a person from witness to accused. After considering the materials collected by the person IO, I am of the view that for the interest of proper and effective investigation, change of status of Sukanya Das from prosecution witness to an accused is necessary, as the petition filed by the present IO is allowed, and the status of Sukanya Das is changed and the accused from prosecution witness. The materials which have been found against the accused petitioner, Lordship, I have given that report before the Honorable Court today, my lord. Lordship, after coming to know that the incriminating materials have been found against the accused petitioner, court cannot just be the mute spectator, my lord. Court rightly exercises power, my lord. Lordship, to change the status of the instant petitioner from witness to an accused, my lord. And that too, your lordship, because your lordship, there's a division bench's order. Lordship, our investigating officer, my lord, will submit the report on 22nd, coming 22nd, my lord, before the Honorable Court, which is coming up. This the instant matter of APS is coming up on 22nd, my lord. And your lordship.
What report? Charge sheet? No, what it would submit on 22nd?
Whatever is the status report and all, my lord.
Status report.
Lordship, because the FSL report and all has come against her, the signatures and all, it has been sent for FSL, it has come against her, your lordship. And the IO has obtained lordship prosecution sanction. It has been obtained, my lord. And the matter has proceeded further after the order which has been passed at the learned court below, your lordship, on the impugn order, my lord. 1. We are in April, my lord. The matter has proceeded further. And your lordship, why I submitted the instant petition is premature. Lordship, after lordship, because her name may come, may not come. Lordship, in the supplemented charge sheet. But your lordship, at the face of it, what I have gathered from the investigation officer, my lord, that the materials have been, incriminating materials have been found, and it's substantially established, my
Do you
lord.
want to say that the status of the petitioner presently is not of a accused facing trial, but as an accused who is pending investigation?
Yes, my lord. Lordship, because unless her name appears in the supplemented charge sheet, my lord, she'll be charge sheeted accused, my lord. Now it's on the stage of.
So no charge sheet has yet been filed.
Yes, my lord. So I'm submitting this as a premature application, my lord. And regarding your lordship, the provision of 173(8), to my limited understanding, this stage would come, your lordship, after completion of the investigation.
Investigation is not yet complete.
Lordship, because your lordship, report of police officer on the completion of investigation. The caption says itself, my lord, as section 173 of CRPC. So procedural formalities as per 173(8) would be done, lordship, after completion of the investigation. Lordship, that is my respectful submission. There's no infirmity in the order, impugn, in the instant petition, my lord, so your lordship may not entertain that application.
So my contention is only that, my lord, because of this order, my lord, the court has already taken cognizance against me. Court has gone by the records as per the order, made me an accused. So tomorrow, if they are saying there may not be material against me, the court is rather has compelled the investigating authority by virtue of this order to file a search sheet.
Lordship, my alternate submission is that, my lord,
The
since
court,
they are saying, lordship, there's no report of the IO, lordship, let the records come before this honorable court. Lordship may have a look at the record and proceed
there's
further. Because
there's no report. Just now she says there is no report.
Lordship,
Investigation is not
because
completed.
my lord,
She
my
says
lord,
that the, as
no,
per
no,
my,
my lord,
her information,
lordship, my alternative submission, because after perusal of materials and record,
we are not
lordship,
on
the
that,
order
my
has
lord.
been passed. It's reflected in the
There may
union
be
order.
materials. We are not disputing on that, my lord. Lordship, kindly understand one factor, my lord. Because of the order taken of the cognizance against me,
No,
I have been made an accused. If tomorrow they are saying, they are already saying that there may not be tomorrow, there may not be search sheet against me.
To
If
the
that be so,
context that this
that-
petition is premature, they have come beforehand.
okay,
let me complete. If that is, my lord, only Lordship consider, if that be so, how the court will review the order passed by it, my lord? Because you have taken cognizance against me on the basis of a report.
no, you
or-
have already made that submission.
Yes,
You have already.
that's why I'm saying that the rebutting the statement that there's a final report will come tomorrow. Only then we will proceed against her.
Okay, I'll
Then
pass.
what is the necessity, my lord?
I'll pass on this.
My lord.
Heard Mr. A. N. Bora, learned counsel for the, learned senior counsel for the petitioner. Insisted by Mr.
B. Kaushik.
B. Kaushik. Also heard Ms. B. Bhuyan, learned additional public prosecutor. Let this case be listed for delivery of orders on 20th of April, day after tomorrow. I'll pass.
Obliged.
Obliged.
Obliged. Lordship, original report be a part, it may be reflected.
Yes. Miss Learned additional public prosecutor has submitted a report.
It is 7/4.
Submitted a report dated 7/4/2024. Let that report be part of the case record. Because
It is the lordship. My 439 application.
yes,
Yes, ma'am. In this matter, I was arrested on 8/5/2021, my lord.
8/5/2021.
21. My lord, as on date, I have been in custody for 1076 days, my lord.
In months
1076 days, my lord, as on today.
and in years and months.
It stands, my lord, 2 years, 11th month, 10 days, my lord.
NDPS case.
Yes, my lord. I'm a driver of a company vehicle, my lord, from where some contraband, cough syrups were recovered, my lord, in this case.
What was the recovery of contraband?
14,400 numbers of bottles of
Cough syrup.
phenacetyl codeine phosphate.
You are the,
Driver, my lord.
you are driver
Driver, my lord. I'm the driver, my lord.
and two petitioners are there.
Driver and handyman.
Gentleman, my lord. And
Lordship, may I submit only one thing, Lordship, before you start, Lordship, the scan copy that is on the record, Lordship, that is last order is of 12/1/24, Lordship. After that, it has not been updated.
my lord, I have got the certified copies of all the other sheets, my lord. I have, but if the kindly, there is
How many witnesses have been examined?
4 witnesses examined, my lord.
Out
till-
of,
Out of 8, my lord.
last witness was examined when?
31/5/2023, my lord, PW4.
And thereafter, no witness has
No,
been,
no witness examined, my lord.
and what was the last date?
Last date was 10/4, my lord. I have got the certified copies, my lord. That one. 10/4 it. May I submit this order sheets, my lord, for the results?
Yes, no, let it be part of record.
Yes, my lord. Certified copies.
Yes, Mr. Sharma.
Lordship.
Now, what is your contention is on prolonged incarceration one?
Yes, madam.
Anything else?
No, madam, that is not 2 years. 1076 is a quite long time, madam.
Yes.
And Lordship will also find, madam, from last 1 year, there is no examination of witnesses.
Yes, Mr. Sharma.
Here, Lordship,
They are mainly harping on prolonged incarceration.
Lordship,
So what is your submission?
my submission will be, Lordship, twofold, Lordship. One is, Lordship, it is not always that the PWC are not present, Lordship. There are occasion on the record, Lordship. I have seen on 3 dates, Lordship, I have seen that the PO was on leave, Lordship.
Okay,
That is, Lordship, 19/9/23.
you
And-
was on leave.
Yes, and 30/10/23. And on the third occasion, Lordship, that is on 28/11/23, the counsel for the accused sought time.
You also sought time.
My lord, but I have found, not found any PWs turned up on that day, madam. That is
Whatever
also
it
I
may
have.
be, Lordship, on record, the order states that the counsel for the accused sought time for cross-examining PW. That is reflected in the order itself. Lordship.
Yes, sir. So that is only, if Lordship doesn't consider, that is only one occasion, my lord. And 28,
On which date?
28/11/23.
Yes, on that day, whether prosecution witnesses are present or not, there is,
Not reflected.
that is not.
no,
recorded.
no, perfect.
Okay, anything else?
My lord, I have prepared a small compilation for perusal of both, my lord, compiling some judgments of Supreme Court and our Honorable High Court, my lord, where length of detention was considered one of the factors in granting bail, my lord. So, Lordship may kindly.
Yes.
kindly-
Okay, heard. Mr. M.
B. Sharma.
No,
Oh,
Mr.
MH,
M.H.
MH.
M.H. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Sofikul Islam and Momin Ali, who are detained behind the bars since 8/5/2023,
21.
21 within bracket, for last 2 years, 11 months, 10 days, in connection with special NDPS case number 43/2021, corresponding to Bajari Sera PS case number 85/2021, pending before the court of learned Special Judge Karimganj under section 21C/29 of the NDPS Act, 1985. the gist of accusation in this case is that on, where is the FIR?
FIR lordship will find at page 12, 13, my lord.
That gist of accusation in this case is that on 7/5/2021, one Mintu Seal, IC of Suraibari watch post under Bajarichera police station had lodged an FIR before the officer in charge of Bajarisera police station. Bajarisera police station inter alia alleging that during Naka checking duty at Naka checking point at National Highway number 8 in front of Suraibari watch post at about 9:35 PM, one Tata truck bearing registration number AS01 KC 6150 was intercepted, and on search it was found that some cartons of Fencidil bottles containing what it contains.
My lord, cough syrup, my lord, Fencidil.
The prohibited material is codeine.
Codeine, my lord, codeine based.
Containing codeine phosphate were recovered therefrom. It was found that the cough syrup there were total 144 numbers of cartons containing 100 bottles each in the said carton, and each bottle contains 100 ml of Fencidil cough syrup. The total numbers of cough syrup bottles which were recovered were 14,100. On receipt of the said FIR, Bajarisera PS case number 85/21 was registered under section 21 within bracket C, small c /29 of the NDPS Act, and investigation was initiated. Ultimately, after completion of investigation, when the charge sheet was laid?
It was dated, my lord, 19/7/2021.
Charge sheet was laid on against the present petitioners under section 21C. Charge sheet was laid under
21C, my lord.
21C/29 of the NDPS Act. The present petitioners were arrested on 8/5/2021, and since then they are detained behind the bars. It is submitted by learned counsel for the petitioner that the charges under section 21C/29 of the NDPS Act, 1985 were framed against the present petitioner on
10/12/2021.
on
10/12/2021.
12/2021. However, it is further submitted by learned counsel for the petitioner that out of total 8 listed prosecution witnesses in the charge sheet, only 4 have been examined till date. And in spite of prolonged incarceration of the present petitioners, the trial has not fairly progressed. And therefore, on the ground of prolonged incarceration itself, the learned counsel for the petitioner has prayed for allowing the petitioners to go on bail. Where are your cases? List of cases. Learned counsel for the petitioners has submitted that by keeping the present petitioners detained behind the bars for long period and thereafter delay is caused either by the prosecution side or by the court, and where there is no fault of the present petitioner, it would certainly violate the fundamental rights guaranteed to the petitioners under Article 21 of the Constitution of India. And hence, learned counsel for the petitioner has submitted that the petitioners are entitled to get bail solely on the ground of prolonged incarceration, as in such a case of prolonged incarceration without fair progress of trial, the fundamental rights guaranteed under fundamental rights to life and personal liberty of the petitioners guaranteed under Article 21 of the Constitution of India are violated, and it overrides the embargo of Section 37 of the NDPS Act. In support of his submissions, learned counsel for the petitioner has cited following rulings. Number 1, Ravi Prakash versus State of Odisha, reported in 2023 SCC Online SC 1109. Chitta Vishwas versus State of West Bengal, within bracket, order dated 7/2/2020 in criminal appeal number 245/2020. Next, Nitesh Adhikari versus State of West Bengal, order dated 1/8/2022 in SLP criminal 5769/2022. Shariful Islam versus State of West Bengal, order dated 4/8/2022 in SLP criminal number 4173/2023. Karnal Singh versus State of Odisha, order dated 22/12/2022 in criminal appeal number 2027/22 arising out of SLP within bracket criminal number 9067/22. And bail application order dated 14/9/2023 in bail application number 3215/2023 passed by this court. On the other hand, Mr. B. Sharma, learned additional public prosecutor, has submitted that huge quantity of Fencidil cough syrup has been recovered in this case, And considering the fact that the contraband seized in this case is of commercial quantity, embargo of section 37 is applicable to this case, and therefore he has opposed the grant of bail to the present petitioner. On the plea of learned counsel for the petitioner regarding prolonged incarceration, learned additional public prosecutor has submitted that the delay in trial has been caused due to various reasons which are beyond the control of prosecution side. He has specifically mentioned that on 3 dates, delay was not due to, on 3 dates, when the case was fixed for examination of prosecution witnesses, the trial court could not take up the matter. On two occasions, the presiding officer was absent. And on third occasion, that is on 28/11/2023, the counsel for the accused persons took adjournment. Stop. I have considered the submissions made by learned counsel for the both sides and have perused the materials available on record very carefully. And I have also considered the rulings cited by learned counsel for the parties. Stop. Court rest part, I'll dictate in chambers.
Madam.
The prayer for bail is allowed.
Hmm.
I'm giving justification in chambers.
Madam.
You consider, you look at there will be certain conditions. You go through the conditions.
No.
The bail application is disposed of. The remaining part I will dictate in chamber.
Sure.
Chamber.
I'm deeply obliged.
Next. Without the.
May I please launch? It's a 439 bail application, madam.
You are ready?
Lordship, before my learned friend starts, I had a word with the informant's husband, namely the father of the victim. And he says there are materials with him which he desires to place it before your lordship. Just a week's time, if I may be granted. Lordship.
In fact, my lord, I don't think that there is some other materials, my lord, required to, my lord, place before your lordship. Because already, my lord, such sheet is submitted, my lord. So whatever materials, my lord, collected by the prosecution, that has to be the basis to, my lord, consider my bail application, my lord. It's not that, my lord, something else are required to be placed by the, my lord, family, my lord. So whatever is the, my lord, material, my lord, collected in the investigation as well as the, my lord, search sheet. So there has to be the basis, my lord, to, my lord, proceed. And, my lord, in fact, that is the settled law, my lord. I don't think that there should be some further materials, my lord, that will be, my lord, furnished by the, my lord, family, my lord. In fact, it's a, my lord,
No,
consensual.
at least we have to give the informant a fair chance to place its her case.
In fact, my lord, several dates are there, my lord, and days gone, my lord, and my lord, LCI is also received there, my lord. And he's, my lord, behind the bar since 2/12/2023, my lord. It's more than 4 months, my lord. So what is
The victim has been examined.
No, Lordship.
Oh, no.
Also, the last date was fixed on 33/24 for framing of charge, Lordship.
Okay. Charges have been framed.
That Lordship will have to call for the updated status.
No, we have to hear the informant side, at least what informant want to say.
Yes.
Otherwise, engaging a amicus curiae would be futile if we don't give chance to place the materials.
So that is.
Then
there,
we
my lord.
will consider if those materials are relevant or not.
In fact, my lord, whatever material is, my lord, that is up to them. My lord, so far this case is concerned, my lord. in the
Because your bail is rejected by trial court.
Lordship.
Trial court has rejected your bail.
My lord, I don't have that information, my lord.
Yes, Lordship, on 22/24, it was rejected.
Because rejection by the trial court or by the court below, I don't think that, my lord, that will create some, my lord, impression over this court, my lord, because this is the case, my lord, where, my lord, the Aadhaar card, my lord, that was the basis to determine the, my lord, age of the victim. One Aadhaar card. So your lordship is aware that Aadhaar card cannot be the basis to determine the age of a victim, my lord. There are different high court
No,
judgment.
is it a consensual relationship?
Yes, my lord.
Consensual. relationship.
Consensual, my lord. So how?
No,
No,
No, that is in the
the
subject.
guardian of the victim denies that it was from.
In fact, my lord, in the
okay,
subject.
let her. How much time will you require?
Can it be on 29th?
My
Let
lord,
us give
your-
her one chance.
Your lordship, kindly have a look that, that is, if it is not consensual, then that is up to your lordship. I am just placing your lordship this search sheet at page 22, my lord. Page 22 at serial number 2. So this is the search sheet, my lord, where it is, my lord, stated in 164 statement, serial 2, my lord, at page 22, my lord. In 164 statement, she stated that she has a relation with
Okay,
Muhammad.
okay. So only age is relevant.
Yes, my lord. And as per, my lord,
You have not been indicated what materials.
cannot be, my lord. It is apparent in the, my lord, search sheet, my lord. And prosecution has to be, my lord, proceeded on the basis of this, my lord, material, my lord.
No, then also materials are against you now.
And, my lord, so far Aadhaar card is there, my lord. So that cannot be the basis to determine a, my lord, victim's age, my lord.
No, let her give her one chance. Heard Mr. J. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Ms. B. Chaudhary, learned amicus curiae appearing for the informant. Learned amicus curiae has submitted that she may be given. She has already contacted the informant over phone and she needs some more instructions before this bail application could be heard. And hence prays for some more time for seeking those instructions. The prayer is allowed. Let this case be listed again on 29th.
Your lordship may have it, my lord, part third, because, my lord, if, my lord, if it is, my
No,
lord,
no part heard.
because your lordship has already heard at length, my lord, and only, my lord,
No,
issue
there is
that-
nothing. Your plea is consensual.
Yes,
Age is, there is nothing to be heard at length.
yes.
We only want to hear their story, what story they have. Let us, therefore I am giving her a chance. So, no part heard, 29/4.
Can it be, my lord, 26 if your lordship, my lord?
26, will it be possible?
I'll try.
Okay, 26-4.
No further time, my lord, shall be granted, my lord. Otherwise, several days are gone, my lord. In the
On
name of my
26, you make submission.
lordship.
Okay, in the meantime, a status report can be called for Lordship, if required. Whether
Um,
charges has been framed or not.
Okay.
Lordship.
In the meanwhile, the registry shall call for the status report of the case of the special POXO case number 24 within bracket H/2024 before from the learned special judge Mojai.
Thank you, Lordship.
Lordship, 439 bail application. Petitioner was arrested on 10th of February 24.
Lordship,
439,
69 days.
Service not completed, Lordship.
POXO is there.
So here, Lordship had asked me to take telephonic instruction, Lordship. I had taken the telephonic instruction, Lordship. He has paid for some time, Lordship.
How much time?
Lordship, next week, any date, Lordship.
Okay.
And this is
Heard
already a
Ms. T.
suspect matter.
Rajkar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that some more time may be granted to ensure the service of notice on respondent number 2 by the officer in charge of jurisdictional police station. The prayer is allowed. Let this case be listed again on
Any date, Lord, next week.
26/4.
Please.
Actually, your lordship. 439 application lordship, petitioner is before, he is in custody since 1/11/2022. Lordship, may I see the FIR page 9. Relevant person page 11, lordship. 4 persons were traveling together in a lordship train, and some quantities of ganja was recovered around 104 kgs. And accordingly, the FIR was registered against 4 persons. Now, lordship, may kindly see the seizure list, that is at page 30,
Page?
13, 1/3.
Yes.
At serial number 11, page 14, your lordship will find what they recovered from my position, lordship. Serial number 11. One electronic reservation slip, clip in the name of Sri Suman Das Adhikari, that is petitioner of your lordship. Trade number so-and-so, white PNR number so-and-so, coach number so-and-so, seat number 62. Which the above noted serial number 7 and 11 are seized from the possession of Sri Suman Das Adhikari. So I am taking your lordship to serial number 7, because they are seizurely saying that serial number 7 is seized from my possession. Page 13, lordship, may kindly see serial number 7. One black and maroon colored backpack containing 2 packets suspected to be ganja, that is total quantity is 13.49 kg.
Okay.
And here your lordship will find, just I am taking your lordship to the forwarding report at page 18, I am referring lordship. It starts from page 17. Page 18, your lordship will find that that petitioner of your lordship is Suman Das Adhikari, his name is number 1. And number 3 and 4, considering that nothing was recovered from their possession, they were granted bail. Just I am placing those orders before your lordship.
From whose possession the rest of the
Sandeep Das, accused number 2. Pooja Rajgar, she was granted bail on 11/12/2023. That is serial number 4. And Juma Saha, she was granted bail on 3/8/23. That is serial number 3.
Okay.
Considering that nothing was recovered. So here from my possession 13 kg. So admittedly, considering that aspect, lordship, that section 37 will not apply against me, lordship. And he is in custody since 1/11/2022. Whereas 37 is not there.
Where is the mention that other contraband was recovered from accused number 2?
That is the serial list, lordship, just I'm again pointing out. That in 11 I have pointed out. And in 16 your lordship will find Juma Saha, that is again Juma Saha. 13 against Puja Rajbarbar. And rest lordship that your lordship will find. Rest they have not specifically mentioned.
Then from where was seized? From where 1, 2, 3, 4 was seized?
1, 2, 3, 4, that your lordship will find next that serial number 6, Sandeep Das name is mentioned. Which all are seized from the possession of Sandeep Das. Lordship got it. Serial number 6, one reservation clip of electronic in the name of Sandeep Das. Coach number so and so, page 13, serial number 6, I am reading lordship. PNR Rajdhani, which all are seized from the possession of Sandeep Das. So top, that is from Sandeep Das.
It is not very clear.
Not clear, but subsequently it is said that from me, it is their case, lordship, page 11, page 14, serial number 11. And similarly, lordship, that serial number 16, specific case was that nothing was recovered from her possession. Serial number 16, lordship may kindly see, above noted serial number 14 and 15.
Okay.
So no contraband was there. So considering that aspect, she was granted bail.
No, this
Relying
aspect
on
was
this-
not considered by the trial court.
Not considered.
You raised this plea.
Yes.
How
my
it was
rejection-
dealt with?
Now charges are framed, lordship, under that sections, and but lordship may kindly see that aspect is dealt with. by
Charges
lord-
are framed
charges are framed.
under 20,
22,
22C,
20C. That
20
aspect
B
is-
to C.
Yes,
20
that
B to C.
aspect is already covered with the order dated 11/12/2023 lordship. Paragraph 9 of that order, your lordship will find. 11/12/2023.
Yes.
That charges were already framed, but as no contraband was found. So considering that rigors of section 37 will not affect that, the finding was. And here also, from my position 13 kg, from their seizure unit also.
Footage. It would be.
Yes. This is your submission.
This is my submission. That's why from their seizure list, it shows that it is below commercial, and considering the personal quantity also, other two accused persons were granted bail. And if your lordship takes up that considering that 13 kg, that is below commercial, then section 37 will not apply.
But it is not only 20 B to C.
In absence of
29 is also
29,
there.
lordship, they have to show that the co-accuser said that he in collaboration with me that he was carrying this.
Material under section 29 is not there.
In my humble submission, it is not there.
Yes, Mr. Goswami.
Lordship, section 20B to C and 29, my lord. These are also sections attributed to the my lord petitioner's mind. The lordship will find from the FIR itself, my lord. They all are together in the compartment, my lord, and they were traveling together, my lord.
And they are distributing, my lord, this is the tactics, my lord. They are distributing the contraband among themselves, my lord, so that it doesn't come to my lord commercial quantity. Afterwards, my lord, after interrogation, they were arrested, my lord. And now, my lord, charges are framed again, my lord, under my lord section 20B2C, my lord. And at the time of framing of charges also, my lord, this is not challenged, my lord, that they are, my lord, carrying contraband below commercial, my lord. So, my lord, the trial court, my lord, had framed the charges under 20B2C, my lord, and therefore, my lord, section 37 is, my lord, very much applicable in this case, my lord. Rigors are still there in this case, my lord.
That regarding lordship, that whether charges are challenged or not, that your lordship has already dealt in paragraph 8 of the order dated 11/12/2023 lordship. That was the submission there also, that
It
charges
is-
were not challenged.
Under the joint
Subsequently,
position of
lordship
all
on
these
merit, that
six
case was-
petitioners, 6 persons, my lord.
No, apart from the fact that charges were not challenged.
Yeah.
What materials are there to show
And now, my lord,
that apart from the fact that they are traveling together,
the charge sheet shows that, my lord, they are traveling together, my lord.
traveling together,
Yes, my lord.
but what else is there?
Well, if your lordship, my lord,
Mere traveling together may not
may
bring,
not, my lord, we have to show the, my lord, the link, my lord. Right. So, my lord, regarding that, my lord, my lord may come to the forwarding, my lord, what is stated, my lord. The from third, my lord, the arrested accused persons are habitual offender like ganja, opium, morphine, etc. Purchaser carrying from northeast states and carrying the same to another state by train for commercial purpose and caught red-handed them by checking staff of Guwahati GRPS, my lord. On interrogation, the accused persons confessed their guilt and stated that they purchased the suspected ganja from Dimapur from one unknown person and carrying the same from Dimapur railway station to West Bengal for commercial purpose. So, my recovered suspected ganja were duly seized from the possession of accused persons as per the seizure list.
yes. So, no, apart from the fact that they were found traveling together in the
Yes,
same train.
yes. And after interrogation also, it has been, my lord, revealed as per the, my lord, statements, my lord, that they are traveling together and they have purchased the ganja from Dimapur from one person to carrying the same to another to West Bengal, my lord.
Apart from the statement of co-accused and accused.
Yes,
You have to show the link
not.
that they are traveling together. This is the piece of evidence which links that they have purchased it from a common source.
Not.
And that responsibility is there on the investigating
Not.
agency. Merely finding two persons
Not.
in
That will be lead by the, my lord, evidence, my lord. The evidence has not taken place, my lord. Only now,
no prima facie some material has to be there.
prima facie, my lord, if there is a statement of the co-accused, my lord, that they are together, that can be, my lord, taken care of in the proceeding for bail, my lord. And other things, my lord, I have just, lordship, may if you allow me to see the, my lord, LCR portions, my lord. LCR.
Go through the LCR.
Yes,
Let him go through.
lordship.
How much time will you require?
Whether today or my some other day.
No, it is on you. If you are able to see today,
Yes,
we
today.
will take it up after some time.
Lordship,
Or you go through the.
lordship.
Let
Tomorrow, tomorrow, if it is.
No, if it is possible today or tomorrow,
Tomorrow.
let. Heard
If there is
Mr.
exact, my lord.
Heard
link
Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor, who submits that some more time may be granted to him to peruse the scanned copy of the trial court record so as to make his submissions. The prayer is allowed. Let this case be listed again on 19 of April 2024.
Obliged.
I'm obliged. My appeal is allowed.
Charge sheet has been submitted. Charge sheet has been submitted. You are on interim bail.
Yes, lordship.
You have cooperated in the investigation.
Yes, lordship, on 20, sorry, lordship. A statement has been recorded.
Heard Mr. K. Islam. What is your name?
K. Islam, lordship.
Heard Mr. K. Islam, learned counsel for the petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
115/2023, dated 30/6/2023.
Stop. It is also submitted by learned counsel for the petitioner that by order dated 28/6/2023, the petitioners, namely Kadam Ali, number 2, Saminur Islam, alias Shaminur Islam, and Abu Shama were allowed to go on interim bail by this court with certain conditions. And in pursuant to the directions of this court, the petitioners have appeared before the investigating officer and have cooperated in the investigation. So in view of submissions made by learned counsel for the petitioner and in view of the fact of laying of the charge sheet, the interim anticipatory bail granted to the present petitioners by order dated 28/6/2023 is hereby made absolute.
I'm obliged.
And this anticipatory bail application is disposed of.
17, Lordship, the petitioner is on interim and CD has not been received, Lordship.
I heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this
7th
case
of
be
May.
listed again on 7th of May,
Can it be on any other day, Lordship? 7th,
except 7th,
any 6 of the, on
6th,
9th, Lordship.
9th of May. The interim order shall continue till next day.
Obliged.
Make my lordship, the screen copy was received, lordship. 438 application, lordship, the translated case, lordship.
Yes, what is your submission?
Pensioners absconder in the Sarsit lordship, he was received the summon lordship for the appearance, lordship.
You have received summons,
Yes, lordship.
then you appear.
The lordship, the apprehension of the arrest, lordship.
This case is under POXO or 366. What is the punishment for 366A? Maximum punishment?
I got more than 10 years for as
Oh, it is not life.
10 years.
So court can give bail. There is no bar for the magistrate court
Yes, yes.
in granting bail.
Yes, lordship.
Then where is the apprehension of getting arrested?
The
How-
lordship. Lordship,
You have
the-
received summons.
Yes, lordship.
You appear before the court and pray.
Lordship, the apprehension to the arrest lordship in the judicial custody lordship, the CGM, the case is the tribal by the session.
No, there is no bar that sessions tribal cases magistrate cannot grant bail. Bar is regarding the offenses where punishment is life imprisonment. Then 366A heard, Mr.
So in the victim's statement is their lordship in their cell lordship. My name is not included lordship.
No, but summons have been issued. You appear before the court.
Then bill may I 10 years the trial lordship.
Heard.
In the lordship, the Amanpreet case lordship, the Supreme Court government.
No, I am not understanding you. You have received summons from the committal court. Committal court can grant bail in such cases.
Yes.
There is no bar in
No
granting bail. You pray before the committal court.
The lordship, the honorable court's order is there, lordship, the same category of case lordship.
Show me.
Hmm?
It is 302 where there is bar. Because 302
302.
maximum punishment is death. This is not applicable. No, there is no bar. Heard, Mr. This is item number.
Item number 18 lordship.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shahidul Rahman, alias Shahidul Ali, who is apprehending his arrest in connection with PRC case number 1470/2020, pending before the Court of Learned Chief Judicial Magistrate, Borpeta. Stop. Learned counsel for the petitioner has submitted that the petitioner has received summons from the Court of Learned Chief Judicial Magistrate, Borpeta. However, he apprehends that as the offense involved in this case is sessions tribal, that is offense under section 366A, he may not be granted bail by the committal court on his appearance before the said court. Stop. I have heard learned additional public prosecutor also. Stop. It appears that the petitioner has received summons from the committal court. And it also appears that the offense involved in this case is one of the offense involved in this case is under section 366A of the Indian Penal Code, for which the maximum punishment is, Mr. Goswami,
10 years, madam.
is up imprisonment
Up to 10 years.
10 years.
Extend to 10 years.
And therefore, there is no embargo of granting bail to the, no embargo under section 437 of the Code of Criminal Procedure in granting bail to the petitioner by the committal court. Hence, the apprehension of the present petitioner that he shall be arrested on his appearance does not have any basis. Stop. This anticipatory bail application is therefore dismissed. However, the dismissal of anticipatory bail application would not preclude the Court of Learned Chief Judicial Magistrate Borpeta to decide the bail application, if any, filed by the present petitioner on his appearance before such court on its own merit. With above observation, this bail, anticipatory bail application is disposed of.
May I please, Your Lordship. This is 438 application, my lord. And my lord, petitioner released on interim bail, my lord, and after released on interim bail, my lord, they have appeared before the investigation officer, my lord.
In
And they
both
have
the cases, both the cases.
Yes, my lord, yes, my
Here, madam,
Except-
victim not recovered, madam.
Statement have,
No, not recovered, madam.
but their statement has been recorded as.
lord. Yes, my lord.
Victim,
Yes, my,
but
As
that
per
is-
my
that is
information,
not there
madam.
in the diary. Diary, we have diary.
they have appeared before the investigating officer.
This, 6/3/24.
Whether they have appeared,
Last entry 6/3/24.
whether they have appeared or not.
No, that is not. here.
That is 6/3, my lord. Interim was granted 18/3.
Okay, then an updated case diary would be
Is
required.
required.
Heard Mr.
J. Ali, my lord.
J. Ali, learned counsel for the petitioner, who submits that the petitioner was allowed to go on interim anticipatory bail by order dated 18/3/2024 by this court. And in pursuant to the directions of this court, the petitioners appeared before the investigating officer. Stop. However, learned additional public prosecutor who has produced the case diary of Bilasipara PS case number 47/24 has submitted that the case diary is updated up only
6/3/24.
up to 6/3/2024, and therefore an updated case diary would be required for consideration of the present bail application. Stop. Considering the submissions made by learned counsel for both the sides, and updated case diary may be called for from the investigating officer. Let this
Ten-
case be listed again on
10/5.
10th of May. The interim order shall continue in till next order in both the cases. In
I'm obliged.
1920, same order.
Obliged.
So 438 application, Lordship. FIR is page 9, Lordship.
Case diary is there. Case diary, 164 statement.
Yeah, 161 is there, my lord,
Okay.
and 164 is not available, my lord. The case is that, my lord, the 7-year-old child of the informant has been taken away from her house by her earlier husband, my lord. And the evidence to that effect is that, my lord, where they stay, my lord, that landlord also, my lord, tried to, my lord, convince the other husband to return the child. But he said that if you don't give my money, he will not return, my lord. That is the one independent witness against this petitioner.
May I submit, Lordship?
May I place that witness?
Yes, what is your submission?
Lordship. Lordship, at first, Lordship, FIR is page 9, Lordship. I'd like to read out the FIR, Lordship.
Yes.
Most respectfully begs to state that I am Sufia Khatun, residing as a tenant in the house of Anjuara Khatun at number 1 Nizorapar, Pragati Path, along with me, my mother, sister, and 7 years old son. On 12/3/24, I went for work. At about 11 AM, while I was not at home, my 7 years old son was missing from home and till moment not come to the home. As per my knowledge, I have received a phone call and told me that my second husband
namely Sharifuddin Ali, son of Abdul Khalek, was taken my son, and in lieu of return of my son, he demanded amount of rupees 1,40,000, Lordship. This is the FIR, Lordship. Lordship, actually what happened, Lordship, while this present victim was aged about only 14 days, Lordship, this informant and accused person, someone has married. And after that, since day of 14, Lordship, till date, present accused petitioner, Lordship, he's taken all care, Lordship, as his own son, Lordship. And what happened, Lordship, before registering this case, 1 month before, just Lordship, arises some matrimonial dispute, Lordship, between the petitioner and accused person, Lordship. And in pursuance of that dispute, Lordship, informant, Lordship, left the accused petitioner's house and started to live with her mother in a rental house at Guwahati, Lordship. And after that, in so many occasions, Lordship, present accused petitioner tried to come back his wife to him to continue her their conjugal life, but he became fail. And later on, he thinks that if I took the son, my son, with me, then my wife maybe come to me, Lordship. And only on the basis of that intention, Lordship, victim child taken by the
Now,
accused
where is
petitioner.
the son?
Lordship.
Sorry,
Now,
recovered
Lordship,
from-
victim son already recovered, Lordship. Already recovered. I have annexed one order, Lordship, page 16, Lordship. Annexed 3, Lordship. According to this order, Lordship, victim girl already, victim already recovered and given possession, custody to his mother, Lordship.
Victim
Lordship-
is with her mother.
Yes.
Victim is with his mother.
Yes,
Yes,
victim now, madam, recovered and given to the Zimma
So,
of her mother.
Lordship,
Victim
there
is
is, Lordship, intention was not there, Lordship, to
recovered
kidnap
from him,
such
madam.
minor.
Okay, let him appear before the eye.
Lordship.
Third, Mr.
A.K. Azhar.
A.K. Azad, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 438 of Criminal Procedure, 1973, has been filed by the petitioner Sharif Ali, alias Sharifuddin Ali, who is apprehending his arrest in connection with Nunmati PS case number 61/2024 under section 369 of the Indian Penal Code. The gist of accusation in this case is that on which date FIR was lodged?
Nunmati, Lordship.
Date.
Date, Lordship. Date. Date of FIR was, Lordship.
On 13/3/2024,
13C2.
one Supriya Khatun had lodged an FIR
And it is not in my
before the officer in charge of Nunmati police station that on 12/3/2024, when the first informant went to work, leaving her 7-year-old child at home,
main.
and after returning from the work,
Date
she
and
could
time.
not find her son. Stop. Later on, she came to know that her second husband, Muhammad Sharifuddin Ali, within bracket, present petitioner, has taken away his son, and in lieu of returning the son, has demanded 1,40,000 from the present petition, from the first informant. Learned counsel for the petitioner has submitted that the first informant is the wife of the present petitioner, and when they were living together, there was some matrimonial discord between them, and the first informant left the house of the petitioner, and only to bring her back, he had taken away the son with him. It is further submitted that the son of the petitioner, son of the first informant, has already been recovered and given in Jimma to the mother, that is the first informant of the case. it is also submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Nunmati PS case number 61/2024 and has submitted that there are incriminating materials against the present petitioner in the case diary. However, he has also submitted that the minor son has already been recovered.
Yes, madam. Recovered from the position of.
Recovered from the position of the present petitioner and handed over to
mother.
the mother of the son. Considering these submissions made by the petitioners, and considering the, no, stop, I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Nunmati PS case number 61/24. Though there are incriminating materials against the present petitioner in the case diary, however, considering the fact that the victim has been recovered, is he your son? Or
Yes,
son
Lordship,
from earlier
not
marriage?
Biological son,
Okay.
not biological son.
Okay,
He is the second husband, madam.
Since
Okay.
40 days old, I am taking care.
and what was last line? Fact that the victim has been recovered and there was a matrimonial discord between the informant as well as the present petitioner, comma. This court is of considered opinion that further custodial detention of the, custodial detention of the present petitioner may not be required for the fair completion of the investigation if the petitioner cooperates in the investigation. So in view of above, the petitioner, namely Sharif Ali alias Sharifuddin Ali, is hereby directed to appear before the investigating officer of Nunmati PS case number 61/2024 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Nunmati PS case number 61/2024, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, 1 and 2. With above observation, this anticipatory bail application is hereby disposed.
Most obliged.
This matter earlier came up before your lordship for consideration of bail, and your lordship intended to dispose of the case today, lordship, and fix the matter today.
The interlocutory,
No,
No,
the
main
final-
case.
Main case, main case.
main case,
Main case.
can we,
Just I am handing over one copy, lordship, that are certified copies of the depositions and FIR is there, so that I can place it for your lordship. Here the appellant was convicted, lordship, for 7 years under section 376 and read with section 4.
what is your prayer, what you are seeking in this case?
I am under 482 for squashing the criminal proceeding, my lord. The allegation, my lord, is that, my lord, kindly see, my lord, FIR
Okay,
case
okay.
13.
We'll fix it for hearing.
my lord, on my lord 25/4, my lord, in the lower court date, my lord. Prior to that, my lord, fixed date, my lord. 25/4.
Which is the office note which
Lord 10/4, my lord, can this 10/4/24.
heard Mr. K. R. Patgiri, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. The office note dated 10/4/2024 shows that the respondent number 2 has received the notice issued to him. Hence, the notices issued to respondent number 2 is deemed to be duly served. The NCR of the scanned copy of the PRC case record number 936/2023, which was called for, has already been received. This case is ready for hearing. Let this case be listed for hearing on when you want.
My lord, before my lord 25/4, my lord. Because my lord, is the my lord, and
24,
my lord.
24/4/2000.
Oblige.
Oh, wait. May I please-
This
This
is
one
a
is statutory appeal, my lord. against
heard,
con-
heard
conviction.
Mr. R. Ali, learned counsel for the appellant. Also heard Mr. B. Sharma, learned additional public prosecutor. This appeal under section 374 of the Code of Criminal Procedure from 1973 has been filed by the appellant Jiarul Haq, who Jiarul Haq impugning the judgment and order dated 23/2024 passed by learned additional sessions judge within bracket FTC, Barpeta in sessions case number 127/2022, whereby the present appellant has been convicted under section 451 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 5,000 with default stipulation. The appellant has also been convicted under section 354B of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 10,000 with default stipulation. Issue notice to the respond, okay. No. Since learned additional public prosecutor has appeared for the respondent, no formal notice need to be issued. Call for the case record of sessions case number 127/2022 along with the case diary from the Court of Learned Sessions Judge Borpeta. List this case after receipt of the trial court record. What for this IA is there?
For suspension of sentence, my lord, I am allowed to remain on bail, my lord, case 58, my lord.
Maximum sentence is for
3 years, my lord.
3 years. Yes. Heard Mr. R. Ali, learned counsel for the applicant. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 389 of the Code of Criminal Procedure, 1973, has been filed by the applicant Jiarul Haq, praying for suspension of sentence imposed on him by judgment dated 23/2024, passed by learned additional session judge within bracket FTC Borpeta in sessions case number 127/2022, whereby the applicant has been convicted, quote from the earlier order, conviction. Stop. The aforesaid judgment has been impugned by the present applicant by filing a connected criminal appeal, which has been registered as criminal appeal number 102/2024. Learned counsel for the petitioner, learned counsel for the applicant has submitted that he has a arguable case in the connected appeal and a fair chance of getting an order of acquittal in the connected appeal. He has also submitted that as the applicant has been sentenced to a limited period of 3 years only, maximum period of 3 years only, the 3 years only, comma, unless the operation of sentence imposed on the present applicant is suspended during the pendency of the connected criminal appeal, he would be highly prejudiced if in the event the connected appeal is decided in his favor. Considering the submissions made by learned counsel, learned additional public prosecutor does not object to the said prayer. Hence, the prayer is allowed. The operation of the sentence imposed on the applicant by the impugned judgment shall remain suspended during the pendency of the connected criminal appeal number 102/2024, and the applicant shall be allowed to remain on previous bail granted to him by the trial court. With above observation, this interlocutory application is disposed of.
Deeply.
Yeah, please, Lordship. My lord, this matter may not be taken today, this matter may be taken in the next week, my lord.
Heard Mr. What is your name?
M. Agarwala.
Heard Mr. M. Agarwala, learned counsel for the petitioner, who prays for an adjournment. Stop. If prayer is allowed, let this case be listed after a week.
After, my lord?
After a week.
After-
One, no fixed date.
No fixed date.
None appears for the petitioner on call. List this matter after 2 weeks.
Hey, please, your lordship. Lordship, the conducting counsel is not well, Mr. Esquire. And we seek some time.
My lord, that has happened before. He was not ready for hearing. And even today, he's not ready for hearing. And this is sending such a bad message for the trial courts.
No, but he is,
Any short date.
He'll-
will do.
How
He's-
many
he was
days
in
and
the
how
court
many leftovers?
know what to do now.
Hear me
If
out.
he is not,
If
the
you,
counsel
if-
is,
I'm ready for to submit my part.
but you are respondent.
I am. I'm petitioner of the IA of the interlocutory application.
What is the interlocutory application
That's
for?
for the stay vacation,
Vacation of the state.
vacation of the state.
Okay. When your senior would be okay.
Any date in the next week. any hearing date.
I do not want the stay to carry on for 9, 10 months. It's not good for our judiciary at all.
No, but suggest how to deal with such situation.
I am more than suggesting. I'm just not in only in this court and outside the court. My 90% of my work is outside the court because we really have to do something about this. Otherwise, we're not going to get any investments in this country done, which is our sad tragedy. And we are kind of borrowing from Singapore. But that's not my part of my submission, but that is part of our tragedy. Now, somehow the matter has reached. We have enough time to finish it off. The petition
even
is
if
liable to be dismissed.
Even if I hear you, they have
Yes.
to respond because they have a right to start.
That's
You
true.
have,
That's true. Your lordship may suggest some middle way, middle path, with which I get the relief because, I am the victim here.
Yes.
And the tragedy is the victim. It's not only me, it's my children as well. And the tragedy is that the perpetrator is my own mother and the grandmother of my 2 children. And those are the only 2 grandchildren she has. It's that bad. this
What is
tragedy.
the matter?
It's bank fraud.
This is the last item.
It's bank fraud, my lord. And bank fraud tuning to 6.5 crores in total. But in this particular case, I think it's coming to about 5 crores. Because of which I had to move countries. And still time is being taken away from my children, causing enough instability in our lives. And by causing multiple frauds in the name of companies. This particular case, which I had to do, is in line with actually a DRT case in which I am impleaded as a borrower, even though I never borrowed any money. My signatures were forged. There's a FSL report that I never signed any of those documents. And then I had to go to the trial court, that is a CGM court, as per the notifications.
Okay. One of you brief me about the case, at least.
Lordship, not only in the presence of the conducting counsel, it may be taken up.
No, I am not hearing it.
Can I just brief?
Yes,
Yes.
let me have it.
I
So,
have a-
so
have a-
that,
yes.
so that next time it will take lesser time.
Yes, my lord. So,
You are briefed with the matter. You also know, you also know the facts.
they
Then
must have
listen to her.
prepared it.
I'll note it down.
Thank you very much.
Yes.
So, I'm just going to be very concise about this.
So
I
you have
have a little time.
15 minutes.
Yes.
Wind up by, because we
Yes.
are not completing it.
No, we are not. I'm just apprising the court about what has gone on. So here I am not only proving that the other side is guilty, but I'm trying to prove my innocence
This criminal petition has been filed by them.
by them to quash a case, CR case, that is a complaint case,
Where you are the complainant.
where I am the complainant,
Okay.
number 5767 of 2022 in the trial court.
You have, what you have alleged?
I have alleged a number of crimes committed by them. First being bank frauds. Second being that I have been, my signatures have been forged, not only in the bank documents, but also in company documents, making me resign from the company where I have not resigned. And then there was a plot of land which was part of the mortgage that was sold off. It was in the name of the petitioner one, but it is part of the equitable mortgage that was sold off. And about 7 crimes that I have alleged in there. And there is, of course, more things are surfacing as the cases are going on in DRT and other courts, DRT and civil court. Now, they instituted a case called TS3 in the civil court, which is barred.
No, in the complaint, you have mainly alleged
Yes. in
forgery.
Forgery, fraud, signature fraud, forgery, cheating, and criminal conspiracy,
Criminal
and
breach of trust.
breach of trust, and joint conspiracy.
Okay. So on what ground they have approached?
They have approached the honorable court on the ground that a TS3 was filed,
Civil suit
a
by
civil
them.
suit by them. And I have been removed as a director, but I have been removed by a set of directors who are not legal themselves. And they have filed a case where jurisdiction is barred. Obviously, they didn't go to the NCLT to state their facts because things would have been totally opened up. They have gone to a court which doesn't have jurisdiction under section 430.
Who is Anjita Saikya, your
That's
mother?
me. Anjita Saikya is me.
You are.
Yes,
And Nirupama Saikya?
that's my mother.
Okay,
And
And
Abhijit
Abhij-
Saikya is my brother, younger brother.
okay.
And that's the tragedy of this whole case. That they committed this bank frauds and all other frauds in my absence after my father passed away
Now,
while I
on
was
what
abroad.
ground the proceeding has been stayed?
Mainly on two grounds, that the honorable court who stayed the proceedings perhaps was not aware of this notification, that CGM court is entitled to handle the criminal part of the NCLT, that is the National Companies Tribunal. So therefore, this notification was not, they suppressed facts about this notification. So CGM court was notified on 24th July 2020. I have the notifications and I have annexed it with the main petition. That is in page number 190 perhaps. So therefore, I'm in the appropriate court, which is their main allegation to institute this case, that I'm not in the appropriate court and I should have gone to NCLT. But I am in the appropriate court because under section 435,
Regarding the offenses.
yes, regarding the offenses, and 436, I'm entitled to file, I'm not entitled, actually the statute directs me to file about these offenses in that particular court.
And their plea was that your complaint was not maintainable,
Yes,
as it ought to have been under the provisions of the Companies Act.
yes. That is their
Okay.
main ground. And the TS3, which actually is barred, they trying to use that as a shield. And another fact I should bring to my lordship's attention is that the petitioner is the respondent in TS3. The petitioner number 1 is actually the respondent in TS3. She is the respondent number 8. And here she's become the petitioner.
Okay, now
They've broken all the
now
simple-
regarding
Yes.
regarding your interlocutory application, the point, now this is fixed for final disposal of interlocutory application or
as well as the
main
court.
case.
And they had prayed.
Okay,
The court had ordered on their prayer.
So we have to go into every aspect, all this. No, because the stay was granted on the ground that, primarily on the ground, on the submissions that the complaint is not maintainable. It ought to have been under Companies Act, provisions of the Companies Act. That was the ground.
Primary ground. And I am 100% guided by statute here. Not only that, I also have, I had filed a case in a division bench seeking a OTS and also mentioning that I had not borrowed the amount. So the honorable court, I have that judgment as well with me. had guided me to go to these forums.
Okay, okay, I have understood. Now, it has to be looked into. For that, they have to be heard. When do we fix it?
As soon as possible.
Suggested it, both of you.
From Tuesday.
Tuesday, we have other matters.
Yeah, all of us have matters fixed. That's the thing.
We will take.
We have
up
to
the whole
just,
thing.
we just have to make ourselves, Tuesday is 23rd. Tuesday is 23rd, my lord. Tuesday the 23rd.
Is it okay for you?
25th, my senior will.
Okay, let it be 25th.
25th, we have, yes, 25th, we have cross examinations in other courts. So 23rd,
23rd, we have a cross examination.
What is-
23rd, second half at 2. 23rd?
No, otherwise, if they are not
It
available,
will be available at 2. 23rd at 2.
Cannot say for sure that how long the cross examination will take.
to suggest.
My lord, today was a
25th, second half.
7. 7,
25th, second half at 2.
Yeah.
Okay, fine. Second half of it. Then 20 have, fifth, first half, shall we do? 25th, first half? First half.
or can it be on 7th of May?
Too late. And I am the victim here. I know the pain and trouble I'm
Okay,
going through.
heard, miss. No, no half, only date.
No half, only date.
No.
No, but first.
Heard, miss. Heard, what is your name?
We right.
Heard Miss V. Rai, learned counsel for the petitioner.
7th,
Also heard
7th
Miss
election.
A. Saikya, learned counsel, respondent in person. Miss A. Saikya, respondent appearing in person. Learned counsel for the petitioner has prayed for an adjournment on the ground that the conducting counsel, Mr. S.P. Roy, senior advocate, is not well, and on the ground of his ailment, an adjournment is prayed. Stop. Considering the ground, the prayer is allowed. With with consent from both the parties, this case is fixed.
23rd, my lord. I'm still praying that they should make themselves available on 23rd. Because, something happens, then it's, at least we have 25th perhaps left, 23rd.
Let this case be listed again on 23rd of
Interior order pass earlier.
the interim order pass earlier shall continue till next week.
Nice.
Much obliged.
Okay.